concern about presentation of videos insofar as they're about 7-minute long videos. So
How many are there?
approximately, well, I'll just count real quick instead of guessing. Bro, I'm assuming just the rear door.
Actually, I have them tallied here, Your Honor. We have videos of the entire incident.
Okay. How long is it going to be and how many are there?
The videos regarding the front door are 1, 2, 3, and 4, and the total 8 minutes and 82 seconds for the first.
Between them or each?
Between them.
Between
total.
8 minutes, total of
Yes,
8 minutes?
Yes,
Okay.
and these are the ones of the front door.
Okay.
Then we have rear door videos, and they're on 1, 2, 3,
Rear door.
4, 5, and they total, I was writing them down yesterday, and we might be able to cut some of that out, but they total about 15 minutes.
Okay.
So if I can express the state's concern here.
Yes, go ahead.
Essentially, there's 2 camera angles, front and rear.
Right.
The whole of the videos is about an hour in length from the time that Mr. Little gets on the bus to the time that he's arrested.
Okay.
The videos are broken up into about 7-minute segments, or sorry, 15-minute segments. In some cases, 7-minute segments in others. Ultimately, though, Miss Rowe, I don't believe, has the portion she wishes to give to the jury broken down in segments. Her desire is to start and stop the various video clips at certain points. My concern is if the jury wants to rewatch that, they would be rewatching evidence that isn't necessarily admitted.
Well, what's the total amount of video time you want to play? 24 minutes.
25 minutes.
And
Give myself an extra minute, Mr.
Okay, so go ahead. Do you want to say something?
if I may, if Miss Rowe can remove all videos that she doesn't want admitted, at least in part, from the thumb drive, the state would probably stipulate, but I would ask that at a minimum, the entire length of it from the time Mr. Little gets on the bus to the end be admitted. Every video in that segment, I think, is appropriate. I don't have a problem if all videos come in. Frankly, the state would stipulate to them coming in. But my concern is if that was not her intention of all videos being admitted and watchable by the jury, then we have a problem with the discovery or the evidence.
Okay. So when you add them all up, is that an hour? Is that what I've heard?
An hour for each angle, yes.
Okay. So how many angles?
Well, so let me explain, Your Honor. I think that I can accommodate the state's request, and that is to remove. There are probably at least 2 videos on there that show nothing other than just a bus drive with no communication between the driver. So I believe that I can delete the ones that will not be necessary. And I believe in total, what's left might be able, I don't think it'll be more than about 25 minutes total, but it shows from the minute
Okay.
Mr. Little got on the bus
Just a second.
till arrest.
You were going to say something?
I think there's maybe a misunderstanding of what the state's saying is I don't think we have, my understanding of the rules of evidence doesn't require actual playing every piece of video or audio that's admitted. You can play selective clips and let the jury review the evidence in its entirety. And the state's not asking the court to play or require that the defendant play all videos in this case. I simply want to make sure that we don't have videos on there that are not admitted into evidence on the thumb drive, specifically on the thumb drive that Ms. Rowe intends to mark as the OPD body cams.
No, I'm not seeking to introduce
Okay.
that.
Okay.
Only the bus ride.
So so can you, the segments you want to watch about the 20 minutes, Can you put that on a single zip drive? Edit it and put it on there?
I don't know how, but I can try to find somebody at my office. Maybe they can help me. Mr. Little might be likely can easily help me.
You know, these were submitted, this trial was supposed to go a week ago. And I'm gonna regret asking this question, but why are we talking about this now? Why didn't this get taken care of before the trial started?
So let me explain, Your Honor. This case started last summer.
Okay, yeah, I don't care about that. I want to know about the videos. I mean,
What happened is because I sent Mr. Thompson a zip file with the relevant videos that I intended to introduce as evidence on January 7th. I had email confirmation.
Right, no, I get that, but why isn't this edited in a way? Because we're not going to play a snippet of it and then send the whole video back there. I mean, we're just not going to do that. They're going to get what's been admitted and played in court. And if you want to admit the whole thing, we're going to play the whole thing. But I mean, I guess I don't.
We will likely admit the whole thing, but we will.
You're going to show an hour here.
Yes, maybe. I don't think, Your Honor, I will have to readdress this once
When do you plan to play the video during
my case.
Okay. Mr. Thompson.
And Your Honor, this is not a discovery issue ultimately.
No, it's not. It's a trial management issue. If you're going to present evidence, you need to put it in a manner that it can be admitted and tailored to what you expect to be admitted. It's not discovery at all.
Agreed, Your Honor. I'm simply trying to articulate that this wasn't necessarily something that I would have noticed beforehand. I saw the thumb drive that Ms. Rowe intended to use in trial and saw that it contained all of the videos, and I did not expect that. And so I did just inform Ms. Rowe that needed to be cleaned up, and frankly, I think it can be handled during the lunch hour.
We're going to proceed with your case.
Damn it, forgot
And
to turn my camera off.
and you say you want this to go in. And you know, I'm going to think about, you know, what to do, but we're not going to, I mean, if this video is like an hour or more long and much of it's not relevant, I don't see any value in that. I'm not going to say, well, this is part of it, but the whole thing is going to go back there with the way to play it. There's all this other stuff that's not relevant. Then they're going to want to look at look at it all just because it's there, even though it's not necessarily relevant, which would be wasting their time. So I'm going to think of a way to figure that out. But we're going to go ahead. I mean, I'm sure they're back there waiting.
And I may say one last thing, Your Honor. I think Ms. Rowe can convey the video she wants by simply deleting all but 4 videos from the thumb drive. Or
If you can do that, then
I think
does
that
get it down? Does that get it down to?
I believe so, Your Honor.
20
I
minutes?
believe it'll be, yeah, I believe
Okay, if you
so.
can do that, then that's all I needed to say in the first place. We can call we can get the jury in. And
Okay, this is the sort of thing you usually do
Thompson, you can call your
pre-trial.
first witness.
That's
Yes,
what a
Your Honor. It's
pre-trial
Mr.
conference
Rose.
is for.
Okay. You can actually have him come in and sit back there if you want.
Thank you, Your Honor.
Oh,
But-
wait a minute, before you go, one other thing.
Yes, Your Honor.
This is a small-time case. They didn't know if it was.
You know,
gonna go or not.
yesterday,
Just
there was a
sure.
number of occasions there, Mr. Little, where you were engaging me directly from when I was on the bench, in front of the jury, in front of the panel. I want that to stop. That's completely inappropriate. If you have something you want me to know, you can tell your attorney, and then your attorney will tell me. You understand?
I've been sufficiently admonished, Your Honor.
Thank you. You can bring the jury in. Be seated in the courtroom. And Mr. Thompson, excellent timing. You may call your first witness.
It's on, people. SovCit with an attorney in sweats. Let's do it.
And Mr. Thompson, you may apply.
Thank you, Your Honor. And can you please state your full name and spell the last for the record?
Zachary Rose, Rose.
And how are you currently employed?
I am a supervisor with Intercity Transit.
How long have you worked for Intercity Transit?
Just about 4 years now.
And how long have you been a supervisor?
About 15 months.
Prior to that, what was your job at the Intercity?
Coach operator.
Bus driver?
Yep.
Okay. And is that the only two jobs you've had at Intercity?
I was a cleaner for about 6 months before that.
Were you employed as a supervisor on June 10th, 2024?
I was.
And what were your duties that day?
I was on the road that day.
What's that mean?
You drive around in a vehicle and respond to any incidents that the buses are having on the road, and you check shelters for damage and loiterers and things like that, graffiti.
And shelter, do you mean the bus stops?
Yep.
Okay. Sorry, and I might ask you some clarifying questions on what you guys used terminology versus I think what generally is used.
Right. I'm so used to what we use that it just comes out.
Okay. And did you respond to any incidents on June 10th, 2024?
I did.
And where did you respond to?
I responded to Linwood and G over on the 12 route,
Okay, and what city is that in?
Tumwater.
So Tumwater, Washington.
Yes.
And do you remember approximately what time you responded?
I do not remember the time specifically.
Was it daytime, nighttime?
It was daytime.
So the sun was still out?
Yes.
Does around 7, 8 o'clock at night sound about right?
Yeah.
So you said you responded to an incident over on the 12. Why were you sent there?
I was sent there because dispatch informed me that an operator was upset because they had an individual on the bus that was acting unruly due to them asking about a possible battery they had on their bike.
But you didn't actually witness any of that.
I did not.
Okay. And so when you're dispatched to something like that, you often or almost never witness the incident.
Correct.
And what is your job when you're dispatched to an incident?
Get there and assess the situation. Top priority is always safety with us. So I just make sure everything is safe. If the person is able to keep riding, I try to have great customer service and allow them to keep riding as long as it doesn't affect the driver in a way that's going to negatively impact the way they are driving.
Okay, and so when you responded to Linwood Avenue in Tumwater, did you come in contact with anyone you recognize today?
I did.
And who did you come in contact with?
That gentleman right there, Ken Little.
And let the record reflect that the witness has identified the defendant, Ken Little.
It will.
So many applications.
Did you have a conversation with Mr. Little?
I did.
And what was your main goal in contacting Mr. Little?
Well, I wanted to get the situation calmed down. So I wanted to try and explain to him why the operator had asked him what was on the front of the bike to explain our policy about car batteries.
And in the course of your conversation, did you attempt to remove him from the bus?
I did eventually, once he kept interrupting me and was acting aggressive towards me.
And did you offer any alternatives to, I guess, staying on the bus?
I did. I let him know that unfortunately I couldn't let him stay on the current 12 because the driver was so distraught that it would not be safe for her to continue driving because she'd be more focused on him than the road. So I offered to let him get on the next 12 coming through, and they run every 30 minutes.
Okay. And so presumably after you arrived at this bus stop, the next bus would be there in sometime less than 30 minutes.
Yes.
Okay. And how long did you spend talking to Mr. Little about him getting off the bus and catching the next one?
Probably about 7 to 10 minutes
Okay.
before I called police.
Okay, so you spent 7 or 10 minutes talking to him before you called the police.
Yeah.
How long does a bus usually spend at a single bus stop?
If it's not running a little early and having to sit at a time point, 30 seconds for people to get off or get on.
And what's a time point?
We have points through our route where if nobody's getting on the bus is gonna end up getting really early on its route. So it's got a specific time where it has to stay at that stop until, so for instance, 7:30, if a bus is gonna get to the mall
Did I hear
at
get off or get off?
7:15, but the time point is 7:30, it stays till 7:30 so that it doesn't get to the other end of town 15 or 20 minutes before its time and people miss it.
Okay, so people can rely on the bus times, generally speaking,
Yes,
and not every stop is like that.
no,
So you spent 7 to 10 minutes discussing his option of getting off and getting onto another bus before you called law enforcement. How long did it take law enforcement to show up?
they were fairly quick. I'd say 5 minutes or less.
Okay, and once law enforcement arrived, did you again ask Mr. Little to get off the bus?
I
That
did,
sounds like something I'd say.
At that point, did Mr. Little get off the bus?
no,
By the time Mr. Little was removed from the bus and it was able to proceed, how long had you spent at the Linwood?
close to at least 20 minutes. And then I spent probably another 10 filling out a police incident report for the Tumwater Police.
So you spent about 20 minutes with the 12 that Mr. Little was on and that it wasn't running.
Right,
And it should have been at that bus stop for roughly 30 seconds, you said.
yes,
And were you still writing your statement at the time the next 12 showed up?
yeah, it drove by.
So if Mr. Little had gotten off the bus when he had been directed to by you, he could have very easily caught the next bus
Definitely.
within just a few minutes.
Yep.
Okay, is that the SovCit with the beard to the left? Only pokes his head in once in a while.
Did this delay that bus in running its normal route?
Yes.
It stays no further questions, Your Honor.
Ms. Rowe, you
Thank
may
you.
cross-examine.
I need to speak to you first.
And I need 1 minute to converse with my client.
Sure.
At least they're not conversating.
We will not be able to leave.
I want to dumber down the ticket. Like I want to fight that.
That's that's my best estimation of this conversation.
I see all of these things. That's why it's on. Okay, it's on video. There's Mr. Little. I understand. Thank you. Thank you.
I'm a goofy guy.
Good morning, Mr. Rose.
Good morning.
Mr. Rose, you are indicated that you are a supervisor with the Inner City Transit. Is that correct?
Correct.
Is today being celebrated by the Inner City Transit? Is there a special celebration going on this day?
I'm not aware.
You're not aware that today is Transit Equity Day?
Objection, relevance?
Oh, sweet Jesus. Egg Foo
Are you
Young
talking about today,
and
as in right
dumplings.
now?
Yes, I am.
Okay, sustained.
So you indicate you have been working for Inner City Transit for about 4 years now.
I have.
And can you explain the type of training you undergo to become a supervisor?
Yeah, we spend about.
I'm
so
sure
once you
that's a
get
thing.
hired,
I'm
you
sure it is.
spend 4 weeks on the road, 2 weeks AM, 2 weeks PM. You spend 4 weeks in dispatch, 2 weeks AM, 2 weeks PM. And you spend a week in video and customer comments and another week downtown with the downtown supervisor. And basically you are performing the job with the trained supervisor shadowing you and making sure you're doing everything correctly.
And as a supervisor and as part of your training, are you made aware that public transportation is a civil right?
As long as you are performing, based on our rules of the ride. Yes, anybody can ride the bus.
Do you get any specific training regarding the protections that of this, or go into detail, any specific training regarding conduct
These people are
that
serious.
would be protected as a civil right?
Objection, Your Honor.
It's funny.
Relevance.
No, sustained.
Are you familiar with the statutes regarding bus conduct?
Loosely, yes. I don't know word for word, but I do know.
And as part of your training, are you given specific training as to the process and procedures to removing a person from a bus ride?
Our biggest thing is de-escalation. We don't want to make the situation worse. So that's why I offered an option for him, for the safety of everybody on the bus and the people on the road, to let him get on the next 12 so that the driver was no longer distraught and could also get to his destination.
Mr. So what are reasons that would give you the authority to remove a person from a bus?
Objection. We may
Absolutely.
approach, Your Honor.
Actually, you can stay seated. Members of the jury, I'm gonna have you, the clerk is gonna take you back to the jury room. We're gonna have a short discussion. And then when we're done, we'll bring you all back in. I don't anticipate this will be very long. But I'm notoriously wrong about guessing how long breaks will be.
Mr. Rose.
Oh,
I'm gonna have you step
come
up
on.
Okay.
You can't pull off a sidebar in the damn Ramada conference room here. This is kind of warming up. It's a slow development, but it's good.
Your Honor, Ms. Rowe continues to ask the witness legal questions that require
Yes,
interpretation of law.
yes, she sure does.
This one, in the realm
Calls
of
for a legal conclusion. Objection.
issues, was not egregious, but it's getting there and it's a pattern. What gives him the authority is not, one, relevant, and two, she wants to know about the law. Again, she asked him if he's familiar with the law. She asked about civil rights. It's a pattern.
Good
I
objection.
expressed concern yesterday that Ms. Rowe would go down this path, and she has done exactly
But
that.
too nice.
Ms. Rowe,
Cram it
Your Honor,
down
I'm
her throat
simply
right in front of the
asking
jury.
questions to explore this supervisor's training. They have processes and procedures that that they are trained and must follow And according to their own manuals,
Excuse me, are you here for court?
Yeah.
Okay, are you Mr. Navarro? No, Mr.
If I may, Your Honor.
Yeah, hang on, to hold that thought, Ms. Rowe.
Just stop.
And procedures and the training, and you were doing that. But with regard to his knowledge of the law and ins and outs of statutes, things of that sort, I'm going to sustain the objection in that regard. It's, he's going to testify as to what happened. He already has, but and you can cross-examine him on what happened and what he saw and what he did. You can talk about his training. The jury's going to hear what's alleged to have occurred. I'll instruct them on the law. It'll be up to the jury to determine whether or not they'll apply the law to the facts that they hear from the witnesses. And again, I'll instruct them on the law. And this is really not much different from like in an assault case. You would never ask, well, what actually is an assault? A victim of an assault or alleged victim of assault, what is an assault? You consider grabbing someone by the arm as an assault or something like that? It's not up to them. You just say what happened, and then the jury applies the law to the facts. And so
I can
stay away
streamline that
from
question.
questions about, do you know the statutes and what's allowed and what's not? But, if you want to talk to him about his training, certainly you can do that.
Thank you.
And so, Mr. Thompson, so I guess to the extent that that's clear, I'm sustaining the objection with regard to that. And Mr. Thompson, you can bring him back in.
Thank you.
I'm sustaining the objection with regard to the whole effing objection because it was good. Stop trying to elicit legal conclusions. I am legal conclusions from your dopey client who doesn't know anything. It's not okay.
Ms. Rowe, you may continue.
Thank you. So, Mr. Rose, are you aware of the policies and procedures that for removing a person from the bus?
Many of them, yes. Are you asking like specific rules of the ride for us?
I'm asking whether or not you have a procedure, you have policies and procedures that you are familiar with that have to be adhered to before a person is removed from the bus.
Yeah, we don't remove anybody unless they're violating our rules of the ride.
All right,
And
I take it back. She was trying to get a legal conclusion from the witness, not her own client.
you indicated that
100% wrong.
you were contacted by dispatch. Is that correct?
Yes.
And going back to the question that I just asked, can you explain the procedure that one must follow in order to remove a person from a bus?
Objection asked and answered.
Overrule the objection. You can answer.
So are you asking what I did, my reasoning for removing him from the bus, or the procedure?
I'm asking for what is your understanding of the procedure that must be followed in order to order someone off the bus?
Every situation is different. We arrive on scene. We see what's going on. If something is happening that is going to affect the safety of the ride, then we make a decision like I did. Every case is different. Our goal is not to just remove people from the bus. It's ridership is important to us. So
The procedure that needs to be followed is you arrive on the scene.
Mhm.
You see what's going on. What does that mean?
if they're violating any of our policies,
And what policies can you name off the top of your head that are violations?
harassing a driver, not having proper clothing on, bringing on car batteries, fuel tanks, unruly behavior like profanity, sleeping, riding with no destination. There's several more, but those are some that come to mind.
So your procedure is that you arrive on the scene, you assess the situation. Do you speak to the drivers regarding incidents?
I speak to the drivers regarding their concerns, and then I go and speak to the individual or individuals or whatever their concern is.
So you indicated that in June of last year, you were doing road duty that day.
I was.
And that is where you drive around and respond to incidents that may transpire.
Yes.
These incidents that would transpire on the bus?
Oh my
They can
God.
transpire on the bus, in a bus shelter, at
Sloth speak.
places like the Capitol Mall, the transit centers, anything out in the system
Understood.
that involves intercity transit.
And you indicated that dispatch informed you that there was an unruly passenger in regards to a bike or battery. Is that correct?
Yes.
What is your, so in this incident that happened on this day, when you arrived, who did you speak to?
When I arrived, I first spoke to the driver, and she told me her concern.
Now, do you ever call the driver before you arrive on a scene?
I do not. Dispatch speaks to them. I can hear their call, but I'm not the one speaking.
And so you arrived to the location, and what was your understanding as to what you were responding to?
The driver wasn't sure what was on the bike that Mr. Little had put on the bus. It was the size and shape of a battery, so she was concerned that it was one. That was the main reason for the unruly behavior, I was told by dispatch.
And what type of unruly behavior was described to you?
He was yelling up to her and harassing her.
Yelling up to the driver
Yes.
and harassing the driver?
Yes.
And in what way was he harassing the driver?
I wasn't there.
Objection calls for hearsay.
Okay. I'm gonna, I'll sustain the objection.
I would actually recommend meth to
Did
this attorney. The only
bus
person I can think of.
driver specify what type of behavior was harassing?
Objection calls for hearsay, also relevance.
Sustained.
So you were informed that Mr. Little was yelling and harassing.
Objection, hearsay, relevance.
I'm gonna overrule that objection. That's just. It's not a statement. It's not asking for the record. The question's not addressing a statement, so you can answer that question.
Please repeat it.
You responded to an incident where the bus driver alleged that Mr. Little was being
Objection, hearsay.
harassive. Unruly and harassive, is that correct?
Yes.
Overrule. That's already been answered.
When you arrived, what assessment did you come to as to what had transpired?
I obviously wasn't there, so I couldn't say whether or not anything happened before I got there did happen. But once I got there and the operator driver told me their concern, I walked to the back of the bus or halfway to where Ken Little was sitting. And I tried to explain to him the concern that the driver had about the possible battery on the front of his bike, but he continued to interrupt me and tell me I was violating his civil rights.
Yeah. So far, I'd say she's competent, just merely not good, not compelling, not interesting, not to the point.
You indicated in your testimony that when you assess a situation, you assess the situation for safety. And it is your goal to hopefully de-escalate a situation.
She's got that
where
going
you
for her.
can allow a passenger to continue riding. Is that
Yes,
correct?
that is always the goal.
So goal is to de-escalate and still accommodate the ride. Would that be a fair conclusion?
Yes.
Now, when you are called upon
Look at Golden
and are
being all
acting
nice.
as in your duties, does assessing the situation at times do you get on the bus? Is the bus stopped?
Yes.
And do you ask the driver to get off and talk with you?
I either talk to them up front while they're seated, or sometimes they get up. Sometimes we talk off the front of the bus. It's whatever they're most comfortable with.
So if you arrive onto the scene and you speak to a bus driver while they're seated in their seat, are there other passengers on the bus?
There can be, yes.
And what do you do to accommodate the other passengers' continued ride on the trip?
So if we know it's going to be something that's very delayed, our dispatch will send out a spare bus to continue the route if the one that is currently having an issue can't continue in a timely manner. And if we have the people available, another supervisor can, if there's only one person on the bus or two that don't have any mobility devices or bikes, we can also offer them a courtesy ride if they want to take that offer.
Offer who a courtesy ride?
Any people on the bus that are being delayed.
Oh, okay, so you either bring another bus or offer the other people on the bus courtesy rides to their destination.
Right, if we know the affected bus is going to be able to continue its route after the situation is resolved.
So it seems like inherently in any incident that you respond to, if there are passengers in the bus, they're inherently delayed. And so transit authority tries to accommodate the other passengers while an investigation is going on. Is that
Yes, we
correct?
do our best to do that.
Okay, I didn't want to do it.
Now, when you arrive and you assess a situation, you indicated that you can talk to the bus driver outside, that you could speak to the bus driver while they're still in their seat in the bus. And so you basically meet the parties involved where they're located, it sounds like.
Typically, yes. A lot of times, they'll already be out of their seat. The operator, the driver will already be out of their seat by the time I get there.
Okay. Now, while this investigation is going on, do you also accommodate the passenger who's involved in an incident?
I try to. If it's somebody that is acting unruly, a lot of times just to get the bus continuing on its route and support the driver and the other people on the bus, I will offer a courtesy ride to somebody that's a biohazard or acting belligerent or whatever the case may be, unless I don't think it's safe enough for me to do so because I'm by myself with that person.
Courtesy
But a lot of
ride,
times I will
a
do that.
biohazard.
Is it your normal practice to
What?
order so if you happen to arrive and the bus driver was still sitting in their seat, would you order the bus driver to get off the bus to talk to you?
It depends on the situation. If I think it's going to escalate the situation further, if the driver is concerned, here's what we're talking about, then yes, I will pull the driver off and have a private conversation with them.
Do you have the authority to order a passenger off
I do.
before you've done any investigation?
Obviously, no, we're not going to just walk up and tell somebody they have to get off. We assess the situation.
So you indicated that you obviously wouldn't just arrive and order the person off the bus. You would have to do some form of investigation,
I explained.
speaking to both parties.
Yes.
It's sped up
And this is
now,
all part of the same investigation that you're doing.
and it
for
just
this
sounds
entire
normal.
incident.
Yes.
Now, bringing your attention to the incident that's being addressed in this trial. What did you determine? What was the basis for your request that Mr. Little get off the bus?
So I did not witness anything that happened between him and the driver when I was not there. But when I arrived, the driver was distraught. He was also distraught. When I was trying to explain to him the driver's reasoning, he kept interrupting me and yelling at me with a raised voice. So after a few attempts of me trying to have a conversation with him, I requested that he step off the bus to have a conversation with me, which he also refused to do.
So you indicated that you made a few attempts to have him explain to you what happened?
I was trying to explain to him what the operator's concern was, and I would have been happy to hear his side. I did hear his argument, but he refused to let me explain to him the reasoning for it. I was hoping that my explaining why the driver was concerned about what was on his bike would be able to resolve the situation and we'd be able to all come to an understanding and just get back on the road, but that is not what happened.
So was it your understanding then that the incident between the driver and the passenger regarding a bike, a battery that was on a bike, was it your impression that that incident had occurred basically right before you were called?
No, when the driver had called in to dispatch, I heard that this incident had happened downtown at the transit center.
And when you responded to that location, was it downtown?
No, it was at Linwood and G Street in Tumwater.
And is that very close to downtown or is that a little ways?
It's a ways. I'd say it's about 15 minutes.
So it was your understanding that, well, first of all, who made the call to have a supervisor respond?
The operator called in to dispatch and then dispatch advised me to respond. I was already on my way because I can hear the call when a driver calls in, but dispatch also reached out to me and had me head that direction if I had not heard the call.
So you were, it appears that, so you weren't aware that Mr. Little was actually the one who asked the driver to call for a supervisor?
Correct. I had no idea who he was until he said his name to the officers when they got there.
Now, you have described the driver a few times as being distraught. What do you mean? Describe the distraught. Describe what you mean when you say she was distraught.
She had a raised voice. She was very anxious, talking fast, heavier than normal breathing, just generally unsettled.
So your description of the driver's distraught presentations was a raised voice,
Mhm.
anxious,
Mhm.
talking fast. When you contacted Mr. Little, did he talk to you with a raised voice?
He did.
Did he seem anxious about the incident?
He didn't seem anxious. He seemed angry.
Was he talking fast?
I wouldn't say he was talking fast.
But he was interrupting?
He was interrupting us.
And when you contacted him, did you ask him what had happened?
I don't remember for sure. This was 8 months ago.
So you don't remember whether you actually,
I remember having a conversation with him. I don't remember how I started it.
do you remember ever asking him to tell you what happened?
He didn't seem interested in it. He continued to interrupt me and tell me that it was a violation of his civil rights by her asking what was on his bike, so on and so forth. So
Might he have? Is it possible, when Mr. Little was speaking with you, did he ask you not to interrupt him and to allow him to tell you what happened?
Objection hearsay.
I'm gonna overrule the objection. You can answer that question.
I do seem to recall maybe him saying that.
Saying what? Stop interrupting me?
Yeah,
I want to tell you what happened?
while he was interrupting me. So it was pretty hypocritical.
Now, you indicated in your testimony that you were happy to hear his side?
Sure.
Did you give him the opportunity to hear his side?
We never had the chance because he refused to have a conversation with me. He just kept interrupting me and trying to interject about his civil rights.
No, when someone raises concerns about their civil rights,
Objection.
You can complete your question.
are there policies and procedures that you are supposed to follow?
Specific to civil rights? Is that your question, specifically to civil rights?
Specific to when someone is alleging that his civil rights are being violated? Are there any policies and procedures that you are to follow in that situation?
Specifically to that, we don't have a policy for somebody that says you're violating my civil rights. Our goal is never to violate anybody's civil rights. We want people to ride the bus. We don't care who rides the bus.
Now, you indicated that Mr. Little was being aggressive. Can you explain how he was being aggressive?
The raised voice, he was yelling up at the driver. He was yelling about how she speeds all the time and his general concerns, I suppose, with the driver, just acting in a very unruly way, which in turn caused the driver to be anxious and caused an unsafe situation for the rest of the people on the road and on the bus.
So you didn't see him being aggressive in your presence?
No, that's how he was acting with me. That's why I wanted to have a conversation with him off the bus, away from the other passengers and the driver, and that's what he refused to do.
So the driver spoke in raised voice, seemed anxious, was able to tell you her side of the story,
Yes,
and was talking fast. Would you qualify her actions as being aggressive?
I would say at that point, yes, she wasn't acting calm and collected. She was distraught.
So being distraught equals acting aggressive? Yes or no?
No, I wouldn't necessarily say that.
But you did just agree that the driver was being aggressive.
She was talking in a raised voice because she was anxious. He was yelling at me. There's a difference between the two.
Did Mr. Little ever inform you during your communication with him that he has a hearing problem?
Objection, hearsay, Your Honor, if I may approach.
I'm going to sustain the objection and you can stay seated.
Going back to your policies and procedures, did you offer Mr. Little a complimentary ride?
I did not. He actually walked to the front of the bus while I was outside on the phone with Central Dispatch and said he would get off the bus if I gave him a courtesy ride. However, I informed him I could not do so because I was driving a Ford Explorer and I can't fit a bike inside of that. I did offer him to get on the next bus. At that point was shortly behind.
How many passengers were on the bus?
Mr. Little and one or two other people. I can't remember specifically.
Did any of the other passengers voice a concern about you being at the incident and basically holding up the bus?
Objection, hearsay, and relevance.
I'm going to sustain the objection.
There were one or two other folks on the bus
Yes.
when you arrived. Were they given courtesy rides?
They were not. We did not have another supervisor in the area to respond and perform that.
Now, are you aware that our bus is equipped with cameras?
Yes, many cameras and audio.
Have you viewed any video from the bus incident this day?
Many months ago, yes.
Did you at any time ask Mr. Little to stop any specific conduct?
I believe I asked him to quit interrupting me so I could explain to him the driver's concern and maybe come to an understanding.
Did you ever ask Mr. Little to not speak to the driver? Yes or no?
I don't know that.
Did you ever ask Mr. Little to stop any specific behaviors that had occurred during the incident which you responded to?
I wasn't there for the incident, so I don't know what behaviors occurred.
So you do not recall ever asking or telling Mr. Little, please don't address the driver? Yes or no?
Yes,
Yes, what?
I don't remember specifically.
You asked the question. Ask for a binary response. You got one. And then you said, yes, what? You don't remember your own question?
Did you ever ask Mr. Little whether or not he had an appointment to go to? Yes or no?
No,
Are you aware from the extensive training that you went through, are you aware that before you are allowed to remove someone from a bus, you have to first ask that they stop some specific conduct?
Objection, facts not in evidence.
Sustained.
As part of your training, were you were trained in de-escalation?
yes.
What are the de-escalation tactics that you use?
The best one that I always use is to try and accommodate the person that is being an issue. I try to offer courtesy rides whenever I would have gave him a courtesy ride if I was in the F-150s that we have. I just couldn't fit his bike. So typically that almost always resolves a situation when you offer somebody a ride to wherever they need to go. That's my go-to.
And so if that avenue is not available, what other de-escalation tactics or procedures do you offer?
I usually ask them to have a conversation outside the bus with me where I can tell them, hey, you're distracting the driver, or the driver is uncomfortable with you being on their bus. Can you get some fresh air? and settle down and get on the next one for me. Sometimes that works, sometimes it doesn't.
But asking someone to leave a bus is in it while they are on their way to a destination, that is in and of itself quite inconvenient for the passenger, wouldn't you agree?
It can be. They will not be asked to get off of a bus if they aren't doing anything, though. A huge concern of mine is the safety of everybody on the bus, and if the operator is uncomfortable with somebody on their bus, that's my top priority, is to make sure the driver is comfortable so they can safely perform their job.
So how do you handle it when a driver is uncomfortable with a homeless person who may smell by getting on the bus?
We typically will, if they do smell not good, very bad, and they are a biohazard, that's part of our policy, is you can't ride if you're a biohazard. So a lot of
Spray 'em
times
down
I
with
will end up giving them
Febreze.
a courtesy ride to the Mission downtown or somewhere where they can hopefully get a shower and some clean clothes.
What is a biohazard?
The smell of urine stains, feces, that sort of thing, blood.
Oh, sweet
vomit,
Jesus.
any bodily fluids.
What procedures do you follow if a driver is uncomfortable with a person who is displaying mental health characteristics,
relevance?
presentation?
Sustained.
In your training, is a driver being uncomfortable with a passenger grounds to have that passenger removed from a bus?
Not always. Sometimes I give the operator an option to I ask the person that they're concerned about their destination. And if they aren't acting in an unruly behavior with me and they are, for the most part, calm, and I deem that they can just stay on the bus and I think it's safe for the operator to continue, I will just follow them to that person's destination and make sure they get there safely without any further incident. That way, if anything does happen, I'm right there and can help with the situation.
Did you follow that option on the day of this incident?
I did not, because at that point I did not deem it was safe for the driver to continue, because she was more focused on Ken Little than driving.
Is that Mr. Little's problem?
Objection?
Sustained.
So you're saying your bus driver was more focused on a passenger to the point where she could not continue her bus driving duties?
Correct, because Ken Little was yelling from his seat in the bus up to her.
Is it unlawful for a passenger to address a bus driver?
Objection?
Sustained.
Are there rules publicly posted that a passenger cannot address a driver? Yes or no?
There are rules regarding harassing a driver, yes, posted by Intercity Transit.
Are there rules that prevent a passenger from addressing a driver at all?
Of course not.
In fact, it's probably safe to conclude that this likely happens at times.
Objection? Calls for speculation.
Sustained.
Are bus drivers trained to respond or not respond to passengers?
We train them that they are informers, not enforcers. However, some operators follow that better than others. A lot of times operators will escalate situations before we get there, which makes our job a lot harder as supervisors to de-escalate.
So there are times when the operator escalates situations.
Yeah.
Did you ever investigate whether this driver escalated this situation on this
Objection,
date?
Relevance.
Overruled.
We watched the video from the moment Ken Little got on the bus to the time I arrived, yes.
When you say we, who are you talking about?
Supervisors, fellow supervisors.
Mr. You whisper very loud. So you reviewed the video of this bus ride with supervisors?
Yes,
Did you view the bus driver addressing Mr. Little downtown regarding the battery that was on his bike?
yes,
Did you view the driver angrily tell Mr. Little that he could just get off her bus? Yes or
Objection,
no?
Calls for an opinion.
So could you repeat the question, please?
Did you watched the videos of this incident, correct?
8 months ago, yes,
With your supervisors?
yes,
Do you remember the bus driver asking Mr. Little about a battery on his bike? Yes or no?
I remember that, yes,
Do you remember watching Mr. Little take out his headphones and answer her question? Yes or no?
I don't specifically remember that. I remember the part about asking
Just
about
yes
a
or no?
battery.
No.
That's it.
You don't remember him responding?
No, what I was saying is I remember the part about asking about the battery because that's what this whole situation is based on. I don't remember the specifics of what was said or who did what 8 months ago.
But you viewed her asking Mr. Little about the battery,
I did. That was the whole basis of the video.
and Mr. Little responded, yes or no?
I don't remember what he said specifically.
Not asking you what he said, asking whether or not he responded. Then you viewed the bus driver taking off and going about her route, correct? And you viewed the route going on without incident.
Incorrect.
I didn't finish my question.
Well, there was another incident, so it's an incorrect statement.
What was the other incident?
So the operator had shut their back door a little bit too early, which happens at times because not always, the mirror angles aren't always perfect, and somebody's arm was in the door, and Mr. Little was yelling up at the driver about that, harassing her about closing the door too early, which also escalated the situation further.
So you viewed the driver closing the door on a passenger that was getting off the bus, yes or no?
Yes,
And immediately thereafter, you viewed Mr. Little telling the bus driver that she shut the lady's arm in the door, yes or no?
Objection, facts not in evidence. There's no evidence to support that it was immediately after.
Okay. I'm going to sustain the objection. We're going to take a break. You folks are going to go back to the jury room. And then, I'm not sure how long this break is going to be, but then we'll be back in session in a few minutes. So Ms. Rhodes, just with regard to this line of questioning and cross-examination, this particular witness's opinion, what's in the video, really, you can be seated, really doesn't matter. I mean, I'm told that the jury's going to see this video and they can make what they want, but this witness's opinion of what he saw, or, I mean, I don't, so I mean, it's not really relevant as to what this person observed on the witness, particularly when the jury's going to see the video. And then you can make whatever argument you feel is appropriate based on what the video shows and what your take on it is. I'm sure I'll hear Mr. Thompson's take, and then we'll go from there. But I'm going to, again, just, I don't, this witness's opinion of what was on the video, go through, well, you saw this and then you saw that and you saw that. I don't think it's relevant to the ultimate issue in this case. And so, so again, I'm just going to ask you to move on.
Okay, Your Honor, I understand. In response to that, Your Honor, just so I'm perfecting the record, my line of questioning was simply to ask, to clarify what Mr. Rose viewed.
Right, and the jury will see what he viewed, and they know he viewed it, and then you can put
Understood.
whatever spin on that that you wish to. And so I suspect someone's going to request to use the restroom, which I will allow. Maybe not. Do you have an idea for how much longer do you think you will go?
Not very much longer.
My redirect will be less than 5 minutes, Your Honor.
Could you reduce that into a number in terms of time? Mr. Thompson just told me he had less than 5 minutes.
I probably have less than 5 minutes also, Your Honor.
Uh-huh. At 2 words a minute.
You spent, it's now.
I probably only have 3 questions.
11:25. You have another witness on here. I'd like to get started with that.
No, Your Honor, we're not calling it.
You're not calling?
No, we're not.
Okay, fair enough.
You will be able to take it. Yeah. Do you need to use the restroom, Mr. Wolf? Okay.
Let me go before you go.
Me too.
Just talking for a long time can get pretty parched.
Yeah, no.
What are you saying?
Been known to go. through
Maybe on
6
the back
cups
of
coffee
the
during a
picture.
test.
Oh, my goodness.
In Mr. Little and the driver, is that correct?
Can be seated in the courtroom. Ms. Rowe, you may continue.
So you indicated that there was a second incident of communication between Mr. Little and the driver, is that correct?
Yes,
And that was the incident connected to the driver shutting a passenger's arm in the door.
yes,
And you indicated that Mr. Little informed the driver that she had shut the passenger's arm in the door, correct?
yes.
What was the driver's response?
Objection calls for hearsay.
Sustained.
Did you investigate the bus driver's actions?
And Your Honor, objection at this time, these are not relevant to Mr. Little's
Sustained,
trial.
sustained on the basis of relevance.
And those 2 incidents of communication between the bus driver and Mr. Little were the incidents that you responded to that day.
Yes,
Any other? Let me make sure. Now go back to the recordings that are taken on the bus. The bus has cameras inside the bus.
yes,
Are there cameras outside the bus?
yes,
Are there microphones that pick up sound on the cameras that are inside the bus?
yes,
So they show video and record what's said.
they sure do.
Do the cameras that are on the outside of the bus, do they have video and also record sound?
I don't think the outside cameras record audio. But they typically will pick up, if the doors are open, the interior audio, a lot of times will pick up stuff outside of the bus.
Are you able to access that video, the video while you're there at the scene?
No.
So you called for law enforcement after Mr. Little refused to be removed from the bus?
I did call for law enforcement to help him get off the bus. I still had every intention of letting him ride the next 12. However, he refused to get off, so he got arrested.
So he wasn't immediately trespassed from getting on another bus?
No.
Why not?
It wasn't my goal to have him not ride the bus. It was my goal to ensure the safety of everybody in the community and the people on the bus, to have that driver be of sound mind and be focused and paying attention to the road. And I could get Ken Little on a different bus that was right behind at that time to get to his destination. So I didn't have the intention of telling him he couldn't ride at all. Had he just simply got off the bus and had a conversation with me, he would know that.
Do you know who prepared the video of the incident that you watched?
I believe my dispatcher, Chad, started the video in our system. And when I say dispatch, dispatchers are also supervisors. We bid those jobs, road or dispatch. It's the same title.
Is that video edited in any sort of way?
Only the start and end times. But I don't believe, whenever we start it, if somebody reports an incident, to try and capture the whole event, we will go back 5 to 10 minutes on each end so that we capture the whole thing, because we want to make sure that we get everything. Obviously, when we're not there, we don't know the exact time something starts and something ends. If we cut a video and it's missing a piece, we'll just redo it and go back even farther till we find everything.
Hold on. Now, you wrote a statement for the Tumwater Police regarding this incident, did you not?
Yes, they asked me to.
Do you remember what you wrote in your statement?
I do not.
If I were to show you your statement, do you think that you could use that to refresh your memory?
Objection, Your Honor. There's no question for the witness.
The question was, if he were to see a copy of his statement.
So he earlier indicated that he did not remember. So now she's asking if she see a copy of it. So I'm going to overrule the objection and allow the answer.
Do you believe if you saw a copy of your statement, it would refresh your memory?
Sure.
That needs to be marked as an exhibit, Ms. Rowe.
I will.
They just walk out on me here? What's going on? Oh, she's marking the exhibit.
That's exhibit number 1. If you could take a look at that. Do you remember writing the statement?
I do. You want me to finish reading it, or?
At first, I really just wanted you to identify
Oh,
that.
yes, I do know that I wrote the statement.
the
Yes.
Statement that you wrote.
Yes, that is definitely what I wrote.
If I could bring your attention.
Ms. Rowe, if you could stand with the podium so Mr. Little can hear, please.
I mean, seriously.
If I could, I would like to,
Any objection? All objections.
if I could have you review the first
No, those are just
3
straight
sentences
sweatpants.
of your report.
There's no fashion cover. Those are sweatpants.
Do you see anything in the statement that you would want to change or clarify?
Plain and simple.
Okay, Ms. Rowe, I would have you remove yourself from the witness. Go back to the podium, please. Rather than just stand there.
I don't, in the first 3 sentences, see anything I would change. I wrote down what the operator stated.
And what did the
Time out
operator
dispatch.
state?
Objection, hearsay, Your Honor.
Okay, I'm going to overrule the objection. You can, there's been a lot of testimony about this and he written a statement time. And so I'm going to allow him to answer.
The operator stated she asked what was on a passenger's bike, concerned it may be a battery, which intercity transit does not transport. She stated he refused to answer the question and started yelling, that she was violating his rights and being aggressive.
Okay, thank you. So in this statement, you indicated that the bus driver asked Mr. Little about the battery or what she believed to be a battery on his bike.
Mhm.
And in your statement, you also indicate that she told you he refused to answer that.
That is what she said, yes.
Does that comport to what you viewed?
Objection calls for a conclusion.
She said, I'm going to wait for the court's ruling.
I'm going to sustain the objection.
She told you, she asked him a question and he refused to answer.
Objection, again, hearsay.
Okay, so that's already been asked and answered. He read what was in the statement. Is that correct? Are you just asking him to repeat what he just said?
I'm asking him to, yes, repeat what he said, Your
And
Honor.
I'm going to sustain the objection on the basis it's been asked and answered.
Understood, Your Honor. I don't believe I have any further questions
Mr.
for
Thompson,
this
you may-
witness. Your Honor.
Thank you, Your Honor. I'll keep it brief. Mr. Rose, previously you testified some of the rules, you try to list a number of rules off the top of your head, and obviously there's a laundry list there. Is one of the rules not following bus operators and transit employees' directions and orders?
Yes.
Objection, Your Honor.
On what basis? I think you would ask him about the rules. And I think Mr. Thompson is following up on one of your questions on cross-examination. So I'm going to overrule the objection and allow him to answer.
Again, I'll ask, is one of the rules that passengers need to follow the directions of bus operators and transit employees?
Yes.
And there's been some discussion about batteries, and I want to make sure it wasn't lost. The bus driver's concern was regarding the potential for a battery on Mr. Little's bike,
Yes.
and you guys can't transport batteries.
Yes.
So she was trying to ascertain whether or not the object on his bike was in fact a battery.
She was doing her job.
And again, I'll keep this brief, but you said you would have offered Mr. Little a courtesy ride as one of your de-escalation tactics, correct?
Yes.
What is another de-escalation tactic that you often use?
The other one that I mainly use is to offer, if they're acting unruly or misbehaving or breaking one of intercity transit's policies, instead of telling them they can't ride for the day, I typically try to meet them in the middle and say, hey, just step off of this bus and we can get you on the next one.
Okay.
Which is what I attempted to do.
So when you respond to a bus, you're not there to conduct a full, thorough investigation of the actual incident, correct?
Right. I can't do that. I don't have access to the video or any of that. It's a he said, she said thing, and I have to make a judgment call.
With respect to these situations, what's your, I guess, primary overall concern?
Safety.
And safety, is that an effort to get the buses moving again?
Not necessarily. If it's not safe for the bus to continue, then sometimes it will sit. But
So when you respond to a scene, it's not to determine who was right and who was wrong, but simply to make sure the situation's safe and so the buses can operate. Is that a fair assessment?
yes.
And when you responded, you said about 20 minutes talking with Mr. Little, trying to get him off that bus and onto the next one.
Me and the police, yes. We spent a fair amount of time attempting that.
And you were still writing that one-page statement when the next number 12 arrived.
Yes.
Thank you. No further questions.
Ms. Rowe, any cross-examination or re-cross-examination on Mr. Thompson's questions?
Yes. What is your understanding? What is your understanding of the rule you're referencing that orders passengers to follow transit authority orders?
Transit policy. So if an operator asks somebody to get off the bus because they are sleeping or eating or sitting with their legs up on the seat, acting in a disrespectful manner, refusing to move out of the ADA area for people in wheelchairs or other mobility devices, things like that.
What if a driver orders a person off the bus based on their color?
Objection.
That doesn't happen.
Sustained.
Is, Mr. Rose, is sleeping on the bus prohibited?
It is. It's unsafe. If a bus has to make a hard stop or any other maneuver and the person is sleeping, they can fly into the aisle and hurt themselves or, fly forward if we have to hard brake.
Is it codified by law or by policy?
Can't say by law, by policy, definitely.
Is eating a snack against the rules on the bus?
It is. Eating is against the rules on the bus.
And a person can be removed from a bus for eating a snack?
Typically, we don't do that, but yes, they can. If they refuse to quit and they're making a mess and continuing to just eat and not follow the rules of the ride, they're there for a reason.
So is it posted where the general public would have knowledge that a passenger is not allowed to eat a snack on the bus?
Objection relevance? The rules being posted.
Overruled.
It's posted downtown, it's posted online, yes, anybody can find the rules of the ride.
Did anyone ever open the box to see if it was a battery?
No, I
Objection
didn't need
relevance?
to, it was an ammo crate, I know what it was, but the operator didn't, that's why I was trying to explain to Mr. Little, the reasoning for her questioning, and
But the conclusion was he was not transporting a battery.
correct. I was able to make that, that's not assumption, but I was able to see that right away, I know what an ammo crate is.
And so in conclusion, you did just testify that when you arrive on the scene of an incident, because you're not present for the incident while it happens, and because you are not able to immediately access video and basically rewind and see what happened, you have to make a judgment call.
I do.
And on this day, your judgment call was to remove Mr. Little from the bus
Yes,
based on what you believed to be aggressive and harassive behavior.
the way he was acting with me, yes. The operator told me what happened, and when I went back to speak with him, Mr. Little was acting in a manner that led me to believe with the operator's statements to be true. So my best judgment call for the safety of everybody was to have him get on the next 12 and have the driver continue on.
Did you happen to ask any of the other two passengers whether Mr. Little's conduct was aggressive or harassing?
Objection relevant?
Sustained.
So you based your opinion on Mr. Little's being removed from the bus on how your interaction with he and you went when you arrived?
Objection asked and answered.
It has been, it's been answered again, so I'll overrule the objection.
No further questions, Your Honor.
Mr. Thompson, anything further?
No, Your Honor.
May this witness be excused?
Yes, Your Honor.
You may step down and you're free to go.
Thank you.
Hey, Mr. Thompson, do you have any further witnesses?
No, Your Honor. State rests.
So members of the jury, the state has now rested. And so what's gonna happen now? It's about 15 minutes or 10 minutes before our noon break. Mr. Thompson's gone. I'm gonna wait till he comes back before I start talking again.
And I released the witness, Your Honor.
What's that?
I released my witness, Your Honor.
So Ms. Rowe had earlier indicated she was gonna give an opening statement at a later time. Now is that time. Ms. Rowe, you have 10 minutes.
Good afternoon, ladies and gentlemen. You're being called here today to preside over a case that involves what the state would qualify as unlawful bus conduct. In the state's opening, it indicated that on June 10th of 2024, Mr. Little was riding the bus. He was availing himself of the right to use public transportation. There was communication between the bus driver and Mr. Little on 2 occasions. In the first occasion, Mr. Little was interrupted with his ride to his destination when a bus driver at the downtown station asked him whether or not the box on the back of the bike that he had secured in the bike rack in the front of the bus was a battery or not. Mr. Little answered that question. The bus driver, Mr. Little, actually had to remove his earphones from his personal listening device in order for the bus driver to hear the bus driver actually ask him a second time, was the box on his bike a battery? He answered that question, and it seemed to set the bus driver off. The bus driver immediately tells him, look, I'm just asking you a question, and if you don't like what I'm asking you, you can get off my bus. Mr. Little chose to exercise self-constraint and not reply to the bus driver's initial threat. The bus ride went on. Later in the bus ride, the bus came to a stop and 3 passengers got off the bus. The first 2 passengers got off the bus successfully, but the 3rd passenger was caught in the doors closing as she was getting off the bus. Right after, as she was getting off the bus and landing onto the curb, Mr. Little called to the bus driver saying, "You just shut the lady's arm in the door." The bus driver's immediate response was to turn around and yell back at Mr. Little, "She didn't say anything about it, so why are you?" She said it a second time. "If she didn't say anything about it, then why are you complaining? You just need to get off my bus." After this second order to get off the bus, Mr. Little responded by informing the bus driver that she was not allowed to order him off the bus without a valid reason. He then asked the bus driver to please call for a supervisor because he informed her without a supervisor, he was not going to leave the bus. Mr. Little was exercising his civil right to be free to utilize public transportation without being harassed unduly by a bus driver. The bus driver complied with Mr. Little's request and immediately called for a supervisor. The bus driver informed the supervisor that Mr. Little seemed pissed. And when she ordered him off the bus, the bus driver indicated on her call that Mr. Little seemed pissed and he was yelling something about violating his civil rights. She never indicated that Mr. Little was being aggressive. She never complained that Mr. Little was being harassive, but she did have the wherewithal to at least notify dispatch that Mr. Little had just exercised and his civil right to continue on to use public transportation.
The
A supervisor was called.
Ride the bus.
The supervisor arrived and the bus driver explained her side of the story. What she indicated was that she asked Mr. Little about the battery and his response seemed a little snippy, and that he had alerted her to the fact that she had closed someone's arm in the door as they were getting off the bus. Then Mr. Rose, the supervisor, got onto the bus and began to conversate with Mr. Little. He asked Mr. Little what happened, and Mr. Little began to explain to him what had occurred. Mr. Little was offended. Mr. Little was distraught.
Boo.
By the supervisor's definition of distraught. He was anxious, he was angry, and he was clearly invoking his right not to be removed from a bus for no reason.
It's unforgivable.
He did not
I already said
commit
converse
any
earlier
unlawful conduct.
in this trial.
We heard from the state's witness itself. Excuse me, I'm going to withdraw that. What we have today is a situation where Mr. Little was unlawfully removed from the bus. He had engaged in no prohibited conduct.
Oh no.
There was no lawful reason
It wasn't
to have
lawful
him
law.
removed from the bus.
Objection, argumentative.
Okay, I'm going to sustain the objection. There's an opening statement. The argument comes later.
And unfortunately for Mr. Little, he was arrested on this day. The court has read the applicable statute that the jury must follow. And that statute first requires transit authority to ask Mr. Little to cease
Your Honor, objection
some.
and argumentative.
I'm going to sustain the objection. I'm going to remind the jury, because the lawyer's remarks and statements aren't evidence or the law. The law is going to be contained in my instructions at the conclusion of the case. The evidence is you're going to hear from witnesses. And with that, Ms. Rowe, you have an additional 2 minutes of your time.
You're going to hear testimony from Mr. Little, and you're actually in the unique position to be able to view the transit recording of the entire bus ride. I am sure that once the court lays out the law that you have to follow in
Ooh,
making your decision, and once you view the incident
entire
in real time
bus
on
ride.
the video, that you will find Mr. Little not guilty of engaging in any unlawful bus conduct. Thank you.
I did not
Members, thank you,
engage
Ms. Rowe.
in
Members of the jury,
unlawful
we're now up
bus
against the noon hours.
contact
We're
with
gonna take
that
our
there
lunch break,
woman.
and we'll be back in session. We'll be back in the jury room by 1:25. We'll start with
I'm
the
losing it.
defense case at 1:30. The instruction I gave at the beginning yesterday afternoon remains in place. Don't talk about this case. You can eat lunch together. Sometimes people bring lunch, sometimes people go to lunch. You can eat lunch together. That's totally fine. But don't talk about what you.
Okay, we're gonna move to the next one here.
As a result of this breakdown in communication, Mr. Little is electing not to testify. And so I wanted to make sure we address this outside of the jury.
Right. You know what? I actually caught some of the
It's my-
conversation.
Opinion that our communication broke down when it comes to the questions that Mr. Little may or may not have wanted
Oh my God.
me to ask.
I'm having a breakdown in
Um,
communication with you.
So Mr. Little is indicating that he is not electing to testify.
Okay.
Okay.
Then, well, I'm gonna need to adjust
I'd like to address the court, Your Honor.
with
The
that.
Law Talk with
I would
Mickey
like to address the
exclusive.
court.
Um,
Can
I
you
got
follow?
that conversation right here.
okay. What do you wish to say?
Ms. Rowe just handed me this note as I walked back in after the break. It says, I will be notifying the court that you will.
Okay,
not
you need to,
testify."
you need to slow down, okay? To yours, and so I don't understand you frankly when you speak that fast.
Because I don't have my teeth in and they cause me
Okay.
pain. And I rarely ever wear them. I had to take them out at the break. The note says, I will be notifying the court that you will not be testifying and we will let the video speak for itself. I do not disagree that we've broken down communication, but during previous hearings, I made it clear to the court that my own lawyer and defense, Your Honor, in open court, that my stipulation with the continuance was simply because I expected the testimony I expected to impeach the testimony of the driver and use the video as prima facie evidence to essentially refute the prosecution entirely. And unfortunately, right now, most of the evidence is left on the table.
It's a lot of words you don't understand there, son.
And I've asked most of my previous attorney, who is a public defender, this, as you know, is a court-appointed panel attorney. And my previous complaint was that I did not get any communication that I expected an affirmative defense. But this is retaliation for complaints. And no one is willing to put forth the effort to make that case. I mean, I understand this is a simple matter, Your Honor. But the point is, my freedom of information requests predate this incident by months, almost a year. Same issues that we're addressing here about sleeping on the bus, about all those things I raised with them. And there's a mountain of evidence that is not going to be tolerated in a limited court of limited jurisdiction for a misdemeanor at this level. And that's why communication is broken down, Your Honor. This is, as I mentioned, and you'll see in the record, as I made the case to the previous attorney, the previous judge during the previous hearing, that I briefly lost my train of thought. Essentially,
I might be able to clarify a couple of things, but.
Well, before we do that, so Mr. Little, here's where you're at. We're halfway through a trial. The state is rested. It's your time to either testify or present evidence or not. You don't have to. It's not uncommon for folks to not present evidence following the state's case and argue that the state hasn't proven it beyond a reasonable doubt in various elements here and there. And my understanding, I'm learning about this case is I don't know as much about it as anyone else here, but I learned about this just over the course of the testimony here today. And I'll be frank with you, in that my sense is that a lot of things that you think might be relevant and important to this case and admissible and the jury should hear are not. They're just not. And, you know, and Ms. Rowe is bound by rules. She can't knowingly, intentionally violate the rules, ask you questions that she knows that would sustain an objection, and
Your Honor, we've had no.
and things of that sort. So hang on, I'm not quite done yet. You know, you don't. Please don't interrupt me. I promise not to interrupt you. And so that's where we're at. And so we're going to finish the trial, and if you. And again, I think that you need to work with your attorney to see what you want to do here. If you want to testify, you can testify. If you want to not testify, then you don't have to. And there'll be an instruction that says the fact that you didn't testify won't be held against you in front of the jury. I'm going to hear from the state on the Ms. Rose said that, well, we're going to let the audio or the video speak for itself. I'm not sure that's going to happen, because in order to get something into evidence, or you usually, unless it's stipulated to, but you know, that's usually in conjunction with testimony of some sort. And I don't, you know, I mean, if this has taken me by surprise, as I suspect it might be taking Mr. Thompson by surprise. So I haven't done any research in that regard, but that's where we're at here. And so, and I've noticed throughout the course of this trial, because you're right in front of me, you know, you've been fairly demonstrative about writing notes and handing them to Ms. Rowe, and, you know, making sure she does this and making sure she does that. But I'm going to assume too much. You're not an attorney?
Oh, Your Honor, but
Okay, and so you're not trained in the rules of evidence, not trained in the rules of criminal procedure, and there are many attorneys who, frankly, not even sure I do, have a great handle on the rules of evidence. It's a complicated subject, and like I say, there are just a lot of things that you probably want that aren't admissible. But we're going to brainstorm how we're going to finish this trial here today. But we'll go from there. And so now you can speak if you wish to.
Your Honor,
I'll give you a chance too, Ms. Rowe. I saw your hand up behind it.
I understand rules of evidence. I understand how to look up. I've spent a lot of time in the Temple of Justice in the law library looking things up myself. I'm not an attorney. The point that I lost a second ago is that this case is ancillary to an action that I intend to bring under 18 U.S.C. 242 for violation of rights under code of law. Everybody knows this because I made it well known for a year at least. And my point is simply that I have no problem testifying. My point, or my problem, is with the amount of evidence that's being left under the table that would support my.
Yeah.
I'd like to respond.
Well, first, I will let you in a minute. First of all, there's nothing, regardless of what happens here, that's not going to stop that. There's nothing to stop you from bringing a suit. You're free to do that. That's not going to have any bearing on that at all. And I guess
I think the evidence should be introduced now rather than later. And if it doesn't get introduced now, it can't be
what is
introduced later.
this evidence?
I'm not an attorney.
What is the evidence that you wish to? I'm just mainly out of curiosity.
Mostly video and audio recordings that were turned over to me, and also policies, procedures, everything. when I say I have an amount of evidence, I'm guessing somewhere between 75 and 100 gigs worth of information that's been turned over to me by the inner city train. And it includes their training, their policies, their procedures,
Uh-huh.
and also the video.
So
But the
Ms. Rowe,
video
you,
evidence that they've given me is not continuous, Your Honor. They've let things out.
Okay.
I think you overheard something like that.
Ms. Rowe, you wanted to say something?
Sorry, because it wasn't subpoenaed, it was simply what they turned over to me. And when I asked them, why is there pieces missing out of this video? They said, well, if you, I have to show you the email that I got from them. If it's necessary, I can produce it for the court, and I'm happy to do that. But they said that the exculpatory video where she said it wasn't relevant, which shows me on the way into town, not the incidents that happened on the way out. The driver accused me of being in the recording. The driver accused me of being out of control. That's not exactly what she said. I don't remember what she said verbatim. But when I requested the video of the inbound route, the information officer said, well, it was automatically deleted because it wasn't relevant.
So when you say inbound, is that on your way to the bus stop
Yes, sir.
before this
I got on
ever happened?
Walmart, and in the video, you will see the video that I hope you're still able to present.
Okay, but hang on, just so clear, the video before you had any interaction with this bus driver, you say that's the stuff that's missing?
There are several sections. Yes.
Okay,
Right.
but is it before, this was stuff before you had any interaction with this bus driver? How many sections?
Question, I'm not sure what you're-
Well, I've heard about you got into it with the bus driver over a battery in downtown and then got off the bus and then the bus took off and things accelerated. Then we heard about where it happened in Tumwater.
You got the sequence wrong. I got on at Walmart in Tumwater,
Right,
rode downtown without incident, without
Right.
any conversation.
right,
In the video, you will see that I go to the locker and
Right.
retrieve my bike that's broken, and I put it on the bus. And I'm attempting to shuttle my bus back home, or my bike back home, because it's
Right.
damaged. It's got a broken chain and a broken gear lever, or excuse me, a brake lever. So that was my whole point. All I did was go retrieve that bike from secure lockup.
Right.
Put it right back on the bus and go back to where I live in the bushes.
and yeah, and that's when that happened in Tumwater.
Yes, sir.
Okay, and then when you got your bike, that started the interaction with the driver about what's that, is it a battery or
Yes, sir.
not, right? Okay, so whoever told you that the part of the bus ride going from Walmart to downtown was not relevant is 100% correct. It's not.
Your Honor.
And again, I'm just saying that wouldn't, even if you had that wouldn't be admissible. You can disagree, that's fine. I have
Because the
people
bus
disagree.
driver on
Okay,
the
so-
recording to the dispatcher says he was out of control on the way down.
Okay,
And she's
but
using that as the
Okay.
basis. And
But hang on just a second. But that didn't come into evidence. That's not part of this. What's
Mm-mm.
happening is,
Sure enough.
what happened after that. So that's not even an issue. It never came up. It's never, that's not
Much for the
relevant either,
cause.
whether you were out of
Thank
control on the
you.
way down.
It's
That's
the
not relevant at
basis for
all.
the drug. But excuse
Okay.
me, the supervisor said that that's the basis why he showed up in the first place.
Okay,
Because I was out of control and harassing the driver.
okay.
No,
Okay, so hang on just a second. So listen to me. That's not my recollection of the testimony. And we're not going to go much further into this, other than we're going to figure out how we're going to finish this trial here today and then go from there. And if the Tumwater did any sort of, you're free to submit any sort of freedom of information request.
sense a lack of commitment.
May not be available, but the relevant evidence is what happened at the bus station over this battery, and then what happened when Mr. Rose showed up. And there's testimony on that. And your attorney cross-examined the one state witness on that. It's your turn to present a case, and so I guess I'm going to go back to Ms. Rowe wants to say something. So I'm going to hear from her as to what's going to happen here today. And then Mr. Thompson, I don't know if you want to say anything or not, but I'll get to you in a second. Ms. Rowe?
so I've got a few things to respond to. The first thing I want to respond to is when Mr. Little indicated initially, when he started speaking with you, that he believes that there are some retaliatory actions towards him from the state actors.
Okay, I don't know which
That's what
one's
he was
worse.
responding. That's what he was addressing.
I really can't
Not
decide.
retaliatory actions of me towards him. They were what he perceives as retaliatory actions of state actors towards him. And these are based on the civil issues that Mr. Little has been explained and explained and over-explained to him are not relevant in this criminal trial. Second thing I'd like to address is he himself has just acknowledged that there was no communication between the bus driver and he before the video, before they arrived downtown. So although he would like to have shown that video and get things on the record in what seems to be in preparation for his civil case, I had to explain to him, as this court just corroborated, and that is that that portion of the bus ride is irrelevant to this incident.
Okay. So, Mr. Thompson, do you have anything to add to this?
I'm not done yet.
Oh, I'm sorry. I thought you were.
I'm
Neither am
not,
I.
no, I'm not. The third thing that I would like to address is the fact that yesterday, well, first of all, Mr. Little's, to cut a longer argument shorter,
I would appreciate that.
Mr. Thompson, even this morning, has indicated that he has no problem stipulating to the video that shows only the 2 times of the incident that is being litigated today.
Okay.
So I would argue that because he's already stipulated to that, and because it has now been condensed into a much shorter form, that we should be able to play the video. It consists of 5 recordings that total 42 minutes and 69 seconds, some of which, when the jury gets it in front of it, it can forward through. Now, so that would, so I just wanted to let the court know that I did go through, I did delete everything that is not connected to this specific incident and does not show the only 2 times that the bus driver had any communication with Mr. Little. Those are on the video. And I noted that the state did not call its arresting officer. The last video shows contact with law enforcement with Mr. Little, and then it wanes on to actually show the arrest. So if the court, so in conclusion, the totality of the time would be 43 minutes. The reason why, and that is the reason why when Mr. Little read to you what I had written to him, and this is because he stopped speaking with me and would not answer any of my questions. This is when I said, I'll notify the court you won't be testifying. And I was telling him, if that happens and he doesn't testify, we will let the video speak for itself. It is my firm belief that once the court and the jury watches the video, it will see that Mr. Little did not
Okay, you don't need
engage.
to tell me what I'm gonna, it's not important for me. I'm not the fact finder in this case.
Understood, Your Honor.
Okay, are you done now,
I am done now.
Mr. Thompson?
And Your Honor, it sounds like the defendant's not testifying, therefore the video won't be coming in as no foundation can be laid.
Help! Help! I'm being repressed! Bloody peasant!
I would like Mr. Little to be able to
Okay,
be
yeah, I
given
just
the
can you
opportunity
just
to
let me-
change his mind.
Let me think for a
Yes.
second, please. Mr. Little, you wanted to say something?
I beg your pardon. I didn't mean for this to be this long, but the reason why I insisted on showing the video, and my attorney has mentioned that she does not intend to ask me any questions, because the reason I requested, according to Mr. Rose's testimony, I'm the one that requested, as my attorney brought out. I'm the one that requested the supervisor come on site. And the reason is because I needed to report the driver using her cell phone multiple times while she's taking it out of her bag, while she's going down the road in operation of a motor vehicle, speeding in violation of an US SPSCC driveway, the posted speed limit, and failing to stop. I mean, there's multiple traffic infractions that I was attempting to report to the supervisor, and he wasn't listening to any of it. All he
Okay.
wanted to do was get me
So-
on the bus away from the recording where I could be isolated. That's my testimony in court.
Okay.
Will be my testimony. I'm happy to testify.
Okay.
I
So
would appreciate that all
Here-
the evidence, the relevant evidence, which is the fact that I'm trying to report a driver for gross misconduct, or at least serious misconduct, using a cell phone is a moving violation. Doing it 3 times on a single ride is a fireable offense.
okay.
And
So-
that's why they're fighting so hard.
So here's where you're at. So I tend to agree with Mr. Thompson in that in order for you've said you have no problem testifying. But I'm not inclined just to play and I know what Mr. Thompson, what the stipulation was, but
Your Honor,
I'm pretty confident that stipulation came with the expectation that would be accompanied with testimony from Mr. Little. And
Well,
it's,
Your Honor.
and so I tend to doubt there would have been that stipulation absent that understanding.
I disagree, and I believe that even if Mr. Little doesn't testify, the video shows the bus driver and Mr. Little.
Okay.
It in itself is self-authenticating. The jury has had a whole day to see what Mr. Little looks like.
Right.
They will see Mr. Little's presence on the bus. They will get to view the entire portion of the video that deals with the issue litigated today. So I would argue that it is self-authenticating. And even if Mr. Little does not choose to testify, that it would be self-authenticating because you can see the ride itself and you can see the 2 parties that were involved on the video.
Okay, that'd be a no.
And Your Honor, I don't believe it would be self-authenticating since we don't know when it was made. And that's a necessary element of authentication. It can't authenticate itself with a date and time.
So here are your choices,
Seriously?
Mr. Little.
It's the first day in court.
Well, if you choose not to testify, then we're gonna add the instruction, which I took out over the noon hour, but we can add that back in. That says the fact that you haven't testified can't be held against you, and we're gonna proceed to argument. Or you can testify, and then the video will come in and you can provide commentary on that if appropriate. I want to tell you one thing though, and that is if you do testify, if there's an objection made, you need to stop. Do you understand that? Because I will tell you, just based on what you just said, some of the things, and I'm not going to prejudge this, but some of the things may not be admissible and may not be relevant. You need to understand that. So you need to decide with your attorney right now what you wish to do.
My decision has never changed, but I'm willing to testify.
Okay.
All the evidence
Then
to be before
we'll
the
bring the
court.
jury back in and then we'll swear you in and
I-
we'll go forward.
Your Honor, I believe that there are going to need to be some guidelines set forth now, because I
Well, I've already-
believe the court will need to
Okay, so I'm
specifically
going to
let
stop you for a
Mr.
second.
Little know.
Please stop. So I'm not going to tell him right now, yes, you can do this, or yes, you can't do that, because I don't know what he's going to say. What I've already said, I'll say it again. If there's an objection, you need to stop. You understand that? Or if you go beyond that and I find that it's inadmissible, I'm going to tell the jury, you're not there to disregard what you just said, because I'm striking that. So, and I know you disagree with it, and maybe you don't understand my rulings, but that's what we're going to do here today.
My attorney will tell you that I was more than willing to provide abundant discovery for the prosecution,
Well, and like I say, I'll
because the evidence speaks for itself.
I'll end where I began in that, just a lot of it, I think there's a very good chance that it's just flat not admissible, even though you think it might be. But anyway, we're gonna try as hard as we can to get this trial in here today. And then Ms. Rowe on the on this video, you know, do you know where like the stuff that you need to speed through, is that just random bus riding with nothing?
Yes.
Yeah,
Yes.
I don't want to show that to the jury.
It's,
And so I just want to, although Mr., because if it's just peaceable bus riding, that's not helpful. We can even stipulate to that, so they can know
Most-
that.
Your Honor, let me break it down for you. The very first video that I'm seeking to introduce contains the first incident of contact between Mr. Little and the bus driver regarding the battery.
Okay,
The second video is the incident where 3 passengers were getting off the bus and the bus driver
That was
closed
the
the
arm?
third driver in the door.
okay.
And immediately as that's happening, the minute she got out of the door, Mr. Little then communicated with the driver, you just closed the lady's arm in the door. So that's the second video. Third video is where Mr. Rose responds to the incident, him getting on the bus and having a conversation with Mr. Little. That's the third video. The fourth video is mostly just probably doesn't need to be shown. However, it does show that while the supervisor was waiting for law enforcement, Mr. Little got up and told the supervisor that if he could drive him to his location, he'd be willing to get off the bus. And the supervisor saying, I'm sorry, I can't fit your bike in my car, so I can't do that. And then the last video is law enforcement contacting Mr. Little on the bus because Mr. Little had refused to even leave his seat, having some communication with Mr. Little and then arresting him.
So can you fast forward through various
Yes.
places to get to those points?
I most definitely
I
can.
would.
The state won't have an objection to that, Your Honor. The jury is going to get access to all the videos if they so choose to watch the bus ride. So be it.
There can even be a stipulation. This was without incident and everything was fine during that time period.
Mhm.
All right. So Mr. Again, I'll just say it one more time there, Mr. Little. We're going to come in and I'm going to swear you in. And again, if there's an objection, you need to respect it and respond to it. So I'll tell you anything from a practical point of view, you know, if you get into
You're safe.
an argument and pushback and all that sort of stuff, it's probably not going to help you too much in front of the jury. And that's just, maybe I've said too much, but you might want to think about that too.
Those are very wise words, Your Honor.
So we can bring them back in.
And Your Honor, before they come in, can I elect to play the video first and
Okay.
then bring Mr.
Well, let me
Little up?
swear him in. You can find out, lay a little bit of foundation and who he is. And this is going to be a video of the situation. Do that first. I'll just
Okay.
Start with the video.
Mhm.
Copy, try me in absentia, and you're not going to prove anything.
I'm just going to say, I'm going to hold you back there for just a moment. I promise you're close. And that is one thing I was planning on saying before I came down here is I would urge counsel to avoid repetition. You know, this morning I noticed in the testimony, things were repeated several times, which wasn't necessarily necessary. And so just kind of be mindful of that so we can, I still have dreams of finishing this trial today. Go ahead, Ash.
You jacking me around and railroading me through the trial.
You can be seated in the courtroom. So, members of the jury, thank you for your patience. I know we're starting a little bit later than we had anticipated. It's all of my responsibility to run the court on time. So if you're looking for someone to blame, you can blame me. So I apologize for making you sit back there longer than necessary. And when we broke, the state had rested. Ms. Rowe gave her opening statement. And now, Ms. Rowe, you may call your first witness.
Thank you, Your Honor. Your Honor, if I could call Mr. Kenneth Little.
Mr. Little, you can come up here to the witness stand. Raise your right hand. Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes.
You can be seated.
So help me God.
And Ms. Rose, you may inquire.
Miss, I'll let you put your device on first.
I may be able to hear you if you're facing me.
You will be able, you can hear me?
Maybe.
I have a pretty loud voice too also. Mr. Little, if you could you state your name for the record?
Kenneth Little.
And Mr. Little, are you familiar with the incident that is being litigated today?
Yes, ma'am.
I'm assuming you're familiar with the incident because you were the person involved in the incident? You were one of the people?
The victim, yes, ma'am.
And can everyone hear? Okay. Okay. So Mr. Little, I'll ask you to speak just a little bit louder for the jury there.
Thank you.
And during the course of this case, were you able to receive video evidence of the incident as it occurred?
Yes, ma'am.
And was that video evidence provided to your counsel for viewing today?
Yes, ma'am.
Your Honor, I would like the opportunity to address the videos.
You may.
Ms. Rowe, may I retrieve my notes that I was taking?
Yes. Would it be this pile
Yeah,
of
the
things
stack,
right
yeah.
now?
Okay, my understanding is
Mr.
we
Little
can't see the
requested
video
his notes.
here.
So I'm going to hand this to you.
He does testify, but I'm gonna skip
You may.
based upon timestamps given to me by Alyssa.
Is it a battery?
Previous
It's
question.
not a battery, right? No, it's not a battery. I'm just asking a question. Calm down. Calm down. Calm down and get off. Okay? Yes. I'm just looking this. I have a right to ask. Yeah. Got one round trip, friend.
I'm now going to proceed to the second video. And was that you speaking?
Unfortunately,
And does this video reflect what you remembered happening that day so far?
it was just a shock. I mean,
Yes or no?
I'm right in front of
Just yes or
Yes.
no?
She's not complaining. Why are you? Then why is that your topic? Why is that your topic? She's not complaining. Why are you? She's not complaining. Why are you?
So what did you have a listening device in your ears, Mr. Little?
I don't recall at this time.
Let me back the video up a tad. Did you just see yourself remove your earbuds out of your ear?
Yes, sir. Excuse me, Ms. Rowe.
Why are you? Get out of my box. I'm not gonna listen. I'm not listening to you. I'm not listening to you. I'm not listening to you. Supervisor, one location. Oh, yeah, you're right. I'm calling. Oh, civil rights. I'm violating civil rights. Got a bike, got on at Walmart, got downtown, put the bike on, and it has like a military box. But I accidentally hit the battery, got total attitude. Got earplugs, and quiet, can't hear me. And now a lady, she's in the door on her. And I don't know what she did, guys. She said she needs to fight here now because I'm violating civil rights.
Now, when you indicated to the bus driver that she was violating your civil rights, was that as a response to her ordering you off the bus?
Yes, ma'am. Thank you. I beg your pardon.
Nope. So far with the 3 videos we have viewed, with the 2 videos we've viewed, you have, is it your understanding that that's pretty much how things
Yes,
have gone?
absolutely. Except for I turned over the audio to the prosecution and.
I'm just asking you a specific question, is what has you viewed so far, what happened?
Yes.
Now we're gonna open video 3.
Lissa seems to indicate that we will see video, but not now, later. I can't tell you how many times I've checked to see if I've paused the video by accident because Attorney Sloth is that slow. Oh, there's a later. You all know I love sloths.
So is this the time when you were trying to explain to the supervisor your version of what had happened before then?
The first thing he said is, do you want to step off the bus and talk to me? I haven't done anything wrong.
Objection, Your Honor, that was non-responsive.
Sustained.
Maybe I misunderstood the question.
Is this communication, this initial
Sorry,
communication?
let me put these back in. I'm sorry.
I'm sorry. Is this initial communication that you had with the supervisor in this initial communication? Were you trying to explain to the bus driver what happened?
I was trying to report that the driver was using her cell phone, speeding, and failing to make a complete stop at the SPSCC.
Again, Your Honor, non-responsive.
I'll sustain the objection.
Could you repeat the question again? I'm misunderstanding.
When the supervisor got on the bus, did he give you the opportunity to explain the any communication that had
understand that.
occurred between you and the bus driver?
Sorry. He came on the bus and he said, "Do you want to talk to me?" He didn't say, "Hi, my name's whatever, and I'm a supervisor, and I'm here to, can you tell me in your own words what the problem is?" He was very confrontational. First thing he said is, "You want to talk to me?" But it sounded almost like De Niro. "You're talking to me? You're talking to me?" I mean, you can't really tell because the audio is so muted from there. The only microphone is at the front. That's why I'm not going to step off the bus, because I want every word on the record.
Did I
Okay,
amuse you
thank you.
like a clown? It is, but it's good.
Yeah, I know. I've been writing about for 50 years. Yeah. You cannot recognize it.
Did the bus driver ever instruct you to not speak to did the supervisor, excuse me, ever instruct you not to speak to the supervisor?
Objection, hearsay.
Overruled.
Repeat the question, please.
Did the supervisor ever give you instructions to not speak to the bus driver?
No, he
Yes
kept
or
saying, "Just get
no?
off the bus."
Pardon?
He didn't say anything except get off the bus.
I am moving to admit that. Your Honor.
I think they've already been admitted.
Thank you.
Clarify, Your Honor, I believe that's Defense Exhibit 2.
Okay.
That's correct. It was marked as Defense Exhibit 2. So, Mr. Little, after viewing the videos, would you say this is a pretty good representation of what happened that day?
Supreme facie.
And in looking at the videos, it looks like you had 2 instances of communication with the bus driver. Is that what you saw also?
That's what I recall.
The first incident of communication with the bus driver was regarding the box that was on your bike.
Yes, ma'am.
And we viewed the video and saw the bus driver ask you whether that was a battery in that box. Is that correct?
That's correct.
And when she asked that, you gave her an answer.
This is the same size and shape as a battery too, but I'm not going to mistake it for a battery.
So when she asked you, you did give her an answer.
Yes, I said it's a box. I keep my lock. I mean, you can't hear it in the video because we're talking over each other, but my words at the time were, it's a box. I keep my lock and my, I got a few small bike tools in there and a bottle of water. It's a part of a box. But I made that very clear, I believe. If you actually, I can't hear it very well, but if you turn it up louder, I think you can probably make that out yourself. Anyone can.
And this was when the bus driver initially told you you could get off her bus. Is that correct?
Yeah, that passive aggressive, irrational, calm down or get off my bus was miserable. I believe that the legislature.
That's the only question I'm having right this second. Let me write down your answer. Now, when the bus driver,
Get off my lawn while you're at it.
told you to get off her bus, did you respond to that threat?
Yes.
Now, the second incident of contact with the driver. It appears this happened as you were watching 3 passengers in the back of the bus exit the bus.
Yes, ma'am.
And what did you see when the passengers were exiting the bus?
Well, it's not uncommon. It happens more than you think. But I think the earlier testimony was that occasionally drivers close the door too early. I think it was his testimony, if I recall. And that's what happened here. But it took me off guard. It's actually the first time it happened right in front of me. And I said, "You just closed the door in that lady's arm." And I blurted it out. And obviously, in hindsight, now that we're in this position.
So, Mr. Little, what was the person's reaction who was being caught up in the doorway?
Well, I looked out the window and I saw her. I assume it was her significant other. It was a male, approximately the same age, and he was questioning her because if you actually watch part of the other camera angles on the video, you could see that he turns around and he tries to console her, and apparently they're talking about what just happened, and but she seems to kind of gloss over it, and they stood there on the sidewalk and spoke for 15 or 20 seconds or so. I mean, in my recollection, and then they both walked away, but they weren't. I mean, I was really hoping or assuming that.
Mr. Little, you've answered my question thoroughly. Thank you. So when you addressed the bus driver and informed her that you closed the door on the passenger's arm, we saw her response. Did you not?
Yeah.
And her response was, she didn't say anything about it, so why are you? Is that correct? Yes or no?
Yes.
And I believe that once she indicated she didn't say anything, meaning the lady who got off the bus.
And Your Honor, I'm going to object to cumulative evidence at this time. The video's just been played for the jury. They're going to have the ability to watch it. We don't need the witness to testify about what was said in the video.
I'll sustain the objection. You can move on.
After you notified the driver that the doors closed on the lady, did you, it appears, did you?
Mr. Rowe, am I not allowed to give my impression of what I saw in the video?
You need to stop. Let her finish her question, and then you can answer. Go ahead, Ms. Rowe. You can repeat your question.
When you notified the bus driver that she had closed the lady kind of in the door before the lady was completely out, the bus driver did respond, did she not?
Yes.
And by responding, did her response elicit a subsequent response from you?
I wouldn't quite say that's accurate, but I think I'm the one that initiated things when I said, so you admit you closed the door on that lady's arm. She wasn't taking responsibility, and that's what I thought was so incredulous. She didn't even bother to open the door and say, are you okay? You know, I mean, sorry. That's what I thought needed to be reported.
And was the bus driver the person who elected to call her supervisor on her own, or did she call at your request?
Objection calls for speculation. You can't possibly know what motivated the driver to do something.
I think the question was who called, paraphrasing a little bit, who called the supervisor, or whose idea was it? I'll allow him to answer. All over your objection, he can answer.
As we all viewed in video, I requested it multiple times. I expected it. And I would say that I've done that at a supervisor's
Mr. Little?
instruction.
Just wait for a question, then you can ask.
It's the tail end of my question, Your Honor. I have a hard time with verbal reasoning, getting the right train cards in the right order on the right track to leave the station in time. If that is any explanation.
Ms. Rowe, you can ask your next question.
Were these the only two instances of communication that you had with the bus driver, the ones that we saw here on this, during this incident?
Yes, ma'am.
So as a result of the bus driver asking you about the battery, what she perceived might be a battery on your bike, and you answering that question, the bus driver closing the door when the passenger was not completely off the bus.
The rush driver.
Were the two instances of conduct that the supervisor responded to. Is that correct?
In my view, that's an assumption on my part.
Now, when the supervisor arrived, did he ask you what happened?
Oh, ma'am.
What did he say?
We saw it. You want to talk to me? I believe his exact words were, you wanted to talk to me, but maybe we can turn it up and get that verbatim. But as I
And when he
testified
asked
earlier,
you
I thought
that,
it was very confrontational, and there was absolutely no customer service, no introduction, no, I don't know who he is. I mean, I don't know him from Adam, to be quite frank, or what his position is with the company, whether he even has the authority to.
His name is Matt, to be frank.
So he didn't identify
no
him?
former knowledge of that.
We
didn't
still the
identify
naked
himself?
gun
No,
here.
ma'am. He didn't say his name, his job title, his anything.
Did he
Right.
have any badges on?
No, I think if you look at the video again, he might have a shirt with intercity transit labeled, or, you know, but I don't recall. Some drivers wear, or some supervisors wear that. I don't recall whether he was wearing that particular day or not.
So
seen it
since
before,
you
since.
were the person who asked for the supervisor to come to the location, when he arrived, did he ever ask you why you requested the supervisor?
Not once. I requested a supervisor because
Mr. Little, I haven't answered you. Did he ever notify you of any specific conduct that he believed you had engaged in that was unlawful?
he said that I was yelling at him, and I told him that I had hearing damage, significant hearing damage. And I've also made comments to the management of Intercity Transit that there are announcements on the bus. I have a decibel meter on my telephone, and everything over 85 decibels is, I've done industrial work, and, you know.
You have hearing loss.
Yes, ma'am. I mean, I was a quality control inspector and welder and machinist. So I worked in a lot of really loud industrial environments, besides going to Ukraine for 6 months and being on the front line. And I'm not going to finish that.
So did the supervisor ever notify you?
But my point is, I didn't finish my.
You
answer.
answered my question, Mr.
No, I didn't. Because when you asked me about the hearing damage, I told him that the announcements on the bus are only a couple of points less than the 85 decibels. My voice, my speaking voice, isn't any louder than the announcements on the bus. And I can show you. In fact, I took out my phone, I believe, and if we look at a different video, I took out my phone and said, I showed him the actual numbers because it was picking up just the way this microphone is picking up, but it was giving it a calibrated scale.
Okay, so Mr.
How
Little,
loud my voice actually was, and my voice did not exceed the announcements on the bus.
understood. Very, very much understood.
Now I might be, I don't know.
Did the supervisor ever tell you that it was unlawful for you to tell a bus driver that you perceived she closed the door on a passenger who had not fully exited?
Objection, Your Honor. It calls for a legal conclusion from a witness who's not testifying.
Sustained. You can ask your next question.
Did the supervisor ever inform you of any conduct that occurred before he arrived that was a violation of any policy?
No, the only thing I remember strongly was him asking me multiple times, just get off the bus. And I felt like he was trying to isolate me from the recording devices, which I felt were my protection in asserting, not aggressive, being assertive in claiming my civil rights. The legislature says that I'm entitled to full enjoyment. I'm entitled to full enjoyment of the bus. And anything else, unless I've done something wrong in my reading of the law, is a violation of my rights.
And you tried to explain that to him?
Multiple times. I mean, I
Did
told him where
he
to find it in
engage,
RCW.
did he accommodate you by listening
No,
and
he didn't
responding
listen
to
a
your?
word I said, just get off the bus. It's not a violation of your civil rights, he said.
Full
That was the
enjoyment.
officer.
Did the bus
Make love
driver
to that bus
ever
if he wants
tell
to.
you to cease any conduct?
I don't recall any. But the video speaks for itself.
Did the supervisor ever instruct you not to speak to the bus driver at all?
No.
And we heard the testimony of Mr. Rose earlier. And I'd like to review a couple of things with you. Do you remember when Mr. Rose indicated in his testimony that transit authority are not just going to order someone off without assessing the situation?
Your Honor, objection, relevance of his knowledge of prior testimony.
Take a break here right now and send you back into the jury room. And then we're coming up on, why don't we go ahead and take our afternoon break now? If you need a break for the restroom or something like that. So we'll be on a break for 15 minutes. And they'll get instructed on how they decide who to believe. They heard Mr. Rose, they're hearing Mr. Little, they saw the video, and then they're going to make the determination. So I'm going to sustain the objection to that line of questioning, and you can move on to something else.
I will.
You want to take a break now?
Your Honor, may I address the court on the record?
About what?
Am I not allowed to testify about my impressions of what happened at the time? I need a ruling on that.
So you don't need a ruling. Your attorney is the one who makes the arguments. Remember what I said this morning? This is kind of what I was talking about. So the ruling I'm giving right now is Mr. Rose testified this morning, that's in front of the jury. You're testifying now, that's in front of the jury. No, I'm not going to let you give it a critique or of Mr. Rose's prior testimony. You can and have been giving your impression about what happened on the video. Yes, you can do that. I think we've kind of come to the end of that video. So that's the ruling I'm making. And frankly, I'm doing a courtesy, even responding to what because the arguments are made by your attorney. And I made that ruling. You can go back and sit with her. And then you said you wanted a restroom break. We'll reconvene. What are we saying about 2:57? Why don't we reconvene at about 3:07 or 3:08? And then just be careful around, I mean, there's jurors around there, they might go to the restroom as well. Yeah, just, you can go sit with Ms. Rowe for right now, and then, yeah, when they're, wait a minute or two to let them come back, and then you can go to the restroom. I'll be back in a few minutes.
And Your Honor, I'm gonna step upstairs and take a phone call for the office.
Adequately assess the situation.
Objection?
Sustained.
Mr. Little, what is your understanding of the rights that passengers have in using public transit?
Objection calls for legal conclusion that he's not qualified to answer.
I'm going to sustain it also on relevance grounds.
Mr. Little, were you afforded the opportunity of full enjoyment of your ride, of the ride on the bus that day?
Absolutely not. The reason I use the term full enjoyment is because that's what the statute reads at the beginning of the chapter.
So it is. So you believe you were not afforded full enjoyment of your bus ride that day?
Absolutely not, Your Honor. Mr. Rowe, because the legislature started out by saying this is civil rights, okay? And then the next
Your Honor,
chapter, they
objection.
talk about.
Sustain the objection, you can stop, and then Ms. Rowe, you can ask the next question.
Have you had a chance to review the policies and procedures required in order to order someone off the bus?
Objection?
Sustained.
Your Honor, may I confer with my attorney?
She can continue.
Mr. Little, when the supervisor contacted you on the bus, were you yelling at him?
No more than I was yelling in court.
So that is a yes or a no?
I think that's subjective to the point to where I have ringing in my ears all the time. What I can hear is much different than what you can hear. I hear a lot of ringing, and I have to overcome that in order to hear myself, especially if I'm trying to hear myself over someone else. And
So does this cause you, does your hearing impairment cause you to speak in a loud tone?
Ms. Rowe, that's for everybody else to answer.
I'm asking you.
Well, I believe, yeah, based on the input that I get from them, that I don't have to talk so loud. That's why I carry that decibel meter, to keep an eye on it, to say, okay, well, here's the numbers, either yes, I was, or no, I wasn't.
And is that the reason why you are also wearing a hearing device during the duration of this trial?
Yes, ma'am.
And that's based on your hearing impairment?
A lot of damage, yes, ma'am.
Did you harass the bus driver?
Objection calls for legal conclusion.
I'll overrule.
If my demeanor is demonstrative, I think, again, that's subjective, but I didn't use any foul language. I didn't use any pejoratives. I didn't, call anybody names. I didn't use profanity. My argument that both the officers and the supervisor was logical. It was rational. And I was asserting my civil rights. Tell me what I did wrong, except just trying to assert my civil rights. If that's,
Okay, you need to stop, and then Ms. Rowe is going to ask you a different question.
trying to finish the question before, Your Honor.
Were you aggressive towards the bus driver?
No, ma'am, not in my opinion. I worked around a rough crowd for too many years.
So you were not aggressive to the bus driver,
Not in my opinion.
not harassive to the bus driver. Answered her question regarding the battery.
Logically and succinctly, with no ambiguity.
You informed the driver of the door closing.
Yes.
And as a result, of those 2 points of contact with the bus driver, you were arrested.
Yes, ma'am.
In fact, let me back up. As a result of the 2 instances of communication with the bus driver, you were first ordered off the bus by her. Is that correct?
Multiple times. Before we ever.
Then you
left.
were secondly ordered off the bus by a supervisor.
Yes, ma'am.
And lastly, you were ordered off the bus by law enforcement.
Yes, ma'am.
And is it your understanding that you were ordered off the bus by the state actors for invoking your civil right to enjoy the full enjoyment of your bus drive?
Objection, facts not in evidence, misstates the law.
I'll sustain the objection, and it's a leading question as well.
Other than that, it's totally cool.
As a result of you and being ordered off the bus, was your subsequent conduct an invocation of what you believe to be your civil right?
I'm sorry, could you repeat that?
As a result of being ordered off the bus, was your subsequent conduct an invocation of your civil rights?
Yes, ma'am. That's the only conclusion I can
One
reach.
last question, Mr. Little. Are you aware of what date is it today?
Today is the 4th of February. Ironically enough, it's the day we celebrate.
Objection, Your Honor.
Sustain.
And is February 4th significant in relationship?
Objection, relevance.
If I could finish my question.
You can
Your
finish
Honor.
your question.
Is February 4th significant when it comes to intercity transport?
Objection, relevance. Today's
I'm gonna
date has no
sustain the
relevance.
objection. That's-
I have no further questions, Your Honor.
And Mr. Thompson, you may cross-examine.
Thank you, Your Honor. Mr. Little, law enforcement officers, multiple law enforcement officers approached you on the bus on June 10th, 2024, correct?
Correct.
And that was in Tumwater, Washington?
Yes.
Okay, and those officers had a conversation with you for a number of minutes, correct?
Correct.
And they informed you that you needed to get off the bus, correct?
Correct.
And you refused to do so, correct? Let me ask it again. Did you refuse to get off the bus when directed so by law enforcement?
Yes.
Okay. Now, Mr. Zachary Rose approached you on the same day prior to law enforcement contacting you, correct?
Correct.
And he asked you to get off the bus as well, did he not?
That's correct. He asked me to get off the bus.
And you refused to do so.
That's correct.
Now, Mr. Rose went so far as to not only ask you off the bus, but he also added that you were more than welcome to take the next number 12 that was less than 30 minutes behind you, correct?
That was a punitive action, not a benefit to me.
Let me rephrase the question because it doesn't seem like you understood it. Did Mr. Zachary Rose offer you an opportunity to ride the number 12 that was coming
It was
next?
not a genuine offer. No.
Did Mr. Rose offer you to ride the number 12 that was coming behind the one you were currently sitting on?
Asked and answered.
Your Honor, I would ask the court to direct the witness to answer the question.
So,
Just take an Uber, you tightwad.
I'm not going, how can I phrase this? I'm gonna allow, no objection was made to that question. And so I'm not making a ruling, but I'm gonna allow Mr. Thompson to re-ask his question, and then you can answer it as best you can.
Thank you.
Mr. Little, did Zachary Rose offer you an opportunity to ride the number 12 that was coming behind the one you were sitting on?
I have no complete clear recollection unless we could play the video again with the sound loud enough where I can hear it. I don't recall exactly the verbiage that was used.
Then why did you just say, well, it's punitive? So you clearly,
Because everybody's trying to kick me off the bus.
Okay.
They're trying to get me off. I got a broken bike. I'm trying to get home, limp home, and they're just trying to kick me off because that's how they punish people.
Mr. Little, I asked you if he offered it to you, and your response was because it was punitive. So that implies that you did hear the question from him because you formed a conclusion about that question. So I'm going to ask again, did Mr. Rose offer you an opportunity to ride the number 12 behind you?
Yes, he did.
How long would you estimate between Mr. Rose getting on the bus and the law enforcement arresting you? You guys sat there.
I have no idea, but we left late. That's within the video too, but nobody pointed it out.
15 minutes?
I have no idea. It's actually on the video. We can look at it for certain. My opinion doesn't really matter. It's a hard number and the prima facie evidence is right there.
And so looking at the defense exhibit 2, there's 5 videos on this thumb drive. Here's timestamps. So the last video is about 6 minutes long, and the video just before that is 5 minutes long. Now, the second to last video Miss Rowe played for you, that was the video where you and Mr. Rose were having a conversation, correct?
Correct.
And the last video is where you and law enforcement having conversation, correct?
Correct.
So in total, that was about 11 minutes. And the other video, which is about 7 minutes long, video number 3 on there, that's the first time that you and Mr. Rose have a conversation though, correct?
I don't recall the order.
So in grand total, though, we're looking at somewhere in the ballpark of 15 minutes. Is that a fair assessment?
Yes, I think so.
Okay. And you were asked by more than one person to get off that bus, correct?
Correct.
Yep. You spent a lot of time discussing the person who, as you phrased it, got caught in the door, but their arm didn't actually get caught in the door, correct?
Absolutely not. Her arm was clearly in that door. You can see the door actually stop motion before it comes back together after she pulled her arm out. Look at it closely. I was there this feet far, 4 feet away.
And you're not a lawyer, correct?
No, I've not taken the bar exam.
Did you attend a law school?
Objection, Your Honor, relevance.
You spent a lot of time discussing the laws.
Sustain the objection. Continue, you can ask your next question.
Now, you asked, or you proposed a courtesy ride to Mr. Rose, correct?
Incorrect. He was the one off that. It's on the video. And I told him, can you take my bike? The one that you saw, that Miss Rose, or excuse me, that Miss, my lawyer, sorry. What's your name again?
Ms. Rowe.
Ms.
Ms.
Rowe.
Rowe. I called you Rose for a second and I couldn't make the connection. If you look at the video and rewatch it again, you will see that he said, I can give you a ride. I said, and he offered that. He said his testimony was that he tries to do that. He did. And I said, I got a bike on the front. Can you take? No, I can't take your bike. It's like, can you just follow the bus to Walmart, which is only a mile away? I mean, but the audio evidence that I gave you from the dispatcher.
And Your Honor, objection.
Sustain.
So you never proposed a courtesy ride.
I did secondary after his initial offer and then retract the offer because he couldn't take my bike. And then I said, in the presence of everyone, not just the supervisor, if you can give me a ride and take my bike, which is broken, which I can't ride. I mean, we're only a mile from where I sleep. I said, all you got to do is give me a ride. Just, I can ride in the supervisor's vehicle, follow the bus a mile to Walmart to get off my bike.
So you were willing to get off the bus.
I was willing to get home in an expeditious manner as quickly as possible. If that would get me home instead of sitting there waiting for somebody to violate my civil rights, I'm happy to do that. I'm just trying to get from point A to point B with as little, nonsense as possible.
So again, I would ask, you were willing to get off the bus.
I was willing to get home. If that would get me off the bus, getting off the bus was not the issue. Getting home in a timely manner was the issue.
Mr. Little, I'm going to ask it as a yes or no question because that's how I've asked it. You were willing to get off the bus, correct?
I was conditionally willing to get off the bus. That's correct.
So conditions on your terms and your terms alone.
In my reading of the law, I'm entitled to full enjoyment unless I've done something wrong. I said simply, tell me what I've done wrong.
But you're not a lawyer. So let me ask again.
You weren't there.
It was conditioned on your terms and your terms only.
No, it was open to negotiation. All I had to do is get me home. It was a simple thing. Just give me a ride, and we're only going a mile, and I can take the bus, or excuse me, take the bike off the bus as soon as we get there. It was a simple solution that, I mean, if you base it on his testimony here, that he really goes out of his way to try and.
Mr. Little, I'm going to ask
Am I allowed
again.
to keep the,
Okay, so just, you can ask your next question, and your attorney will have a chance to ask you questions following Mr. Thompson.
I would either like to finish my answer or have someone object.
So, Mr. Thompson, you may ask your next question.
If I'm saying something wrong, then he should raise an objection, Your Honor. If I'm wrong in my assumption, please correct me.
Okay, I'm just going to have you stop. Mr. Thompson, you can ask your next question.
So your condition was that he had to give you a ride with your bike. That was your condition to get off the bus, correct?
I'm not going to leave my bike on the bus.
Didn't say you had to. That is correct. Mr. Little, is that correct?
Please restate your question.
Your condition for getting off the bus was the supervisor had to give you a ride with your bike. That was your only condition to get off the bus.
No, you're characterizing this completely wrong. I didn't make any demands. I was just trying to get home. I wasn't making any demands of anyone.
So when the jury,
I'm trying to look for a solution. If you can give me a ride home and still just drop off on my bike, I'm happy with that. I'm wasting time here. I got a lot of stuff to do. I walk 200 miles a month besides taking the bus for 80 hours a week. I mean, I'm on the bus a lot. Maybe 80 hours a week is an exaggeration, but I've logged it. And I'm telling you, I'm just trying to get from point A to point B. It takes me 2 hours to get up in Tumwater to go downtown to take a shower and then come back on the bus. So I'm just trying to shorten that up as much as possible.
The ET
Otherwise,
defense.
I get nothing done in any day, and I'm retired.
do you believe that if you just gotten off the bus when Mr. Rose asked you to and taken the next number 12, it would have been quicker than arguing with Mr. Rose for 15 minutes and law enforcement for an additional 10?
Objection, Your Honor, calls for an opinion.
Sustain. You can ask your next question, Mr. Thompson.
If you were interested in going so quickly, why did you not get off the bus when requested?
Because I'd be stranded. I can walk home that fast.
The number 12 runs the same route every day, correct?
Yes,
And so a number 12 was coming shortly thereafter, was it not?
a half hour.
And you didn't want to wait half an hour.
I didn't do anything wrong. Why? Why wait a half an hour when I'm innocent?
You were asked to get off the bus and you didn't want to wait a half hour, correct?
Your Honor, that's asked and answered.
Amen.
I'm going to allow, you can give an answer to that question. And you can repeat the question if you need to.
Please.
You did not want to wait half an hour, correct?
Absolutely not. Not another half hour. She was already late leaving. And the time that she spent arguing on the way affected the schedule just as much as me asserting my civil rights. Look at the video. She was late leaving. There's a beeper that you can hear, an audible beeper, beep, when they're supposed to go. She wasn't even back in the bus yet. I mean, at least half the delay that you're trying to pin on me is from the driver who talks on her phone, speeds, and fails to make complete stops on a campus, a college campus, with nuthead teenagers running around.
No further questions, Your Honor.
Ms. Rowe,
Thank you, Your Honor. Mr. Little,
Yes, ma'am.
before the supervisor or law enforcement got involved, did you hold up the bus?
No, ma'am. In fact, the dispatcher told the driver to keep driving. That's in the audio that I provided to the court, and
Mr. Little?
it hasn't been played in court.
Mr. Little? I understand that this is your day in court, and I understand that you want to be on a truth finding.
Objection, Your Honor.
I understand.
Sustain. You can ask your next question.
Mr. Little,
Yes, ma'am.
did the supervisor contacting you hold up the bus?
No, ma'am. The dispatcher told him to keep going.
When the supervisor arrived and the communication that you had with the supervisor, was it the supervisor's conduct of questioning you partially what held up the bus?
Objection, Your Honor, invades the purview of the jury. The jury's the fact finder.
I'm going to sustain the objection as to the form of the question.
The supervisor offered you a ride, correct?
Yes, ma'am.
But that ride was not feasible because you couldn't also take your bike. Is that correct?
He withdrew the offer when he found out that I had a bike.
The ride was not feasible because you had a bicycle, correct?
Yeah, he said he could do it. He testified that in court. He was driving not a pickup, he was driving an SUV. And that's why when the instance that you pointed out, when I walked up to the front, I said, look, all you got to do is give me a ride and get my bike there too. As long as you can get us both there, I'm happy. I was amenable. I mean, I was trying to find a solution that didn't violate my rights and didn't delay me any longer than I had to be with a broken bike and a lot of other things happening. Just trying to get home.
Is the reason why you refused to get off the bus when the supervisor asked was because you
Objection
didn't?
leading.
I didn't.
Sustained. You can ask what the reason was. Don't suggest it in the question.
When you refused to get off the bus, was it your position that you had not done anything
Objection
wrong?
leading.
So that's sustained.
Don't think I have any other questions.
Anything further, Mr. Thompson?
No, Your Honor.
Mr. Little, you can go back to counsel tables. Do you have any additional witnesses?
I do not, Your Honor.
Or are you resting at this time?
I am, Your Honor. Thank you.
So, members of the jury, we concluded the evidence portion of the trial. Take you back to the jury room one last time. This will be shorter than the last time, I promise. Can't say how much shorter, but hopefully in about 5 minutes, we'll come back out, get your instructions from me, and then argument from counsel. Get a chance to. Did you get a chance to review the jury instructions?
I did, and I have no objection to any of them, Your Honor.
Go ahead and distribute to one for each for Mr. Little, Ms. Rowe, Mr. Thompson. Are the instructions on the seat?
Yes. Yeah, the jury.
Okay, okay, then, well, I guess we can back, will be a short recess. We can go ahead and bring them back in, and sure. Unless someone wants to use the restroom or something. You can just check, see if they're ready.
And Your Honor, how much for closing again?
What's that? 20 minutes?
20
Yeah,
minutes?
20 minutes each.
Understood.
I'm hoping that's enough time.
Well, yeah, you have 20 minutes. Do you have a template that I could get from you?
I think you can get 3-4 words in there. Don't worry about it.
What kind of-
Legal please. You can be seated in the courtroom. So when you came back in, you're holding in your hand now, it says court's instructions to the jury. I'm going to read them to you, each one. And, you know, I've learned and observed over the years, different people have different listening or learning styles. Sometimes most people follow along as I read them. Some people step aside and listen. Whatever your particular style is fine with me, but the law that will apply in this case is as follows. Instruction number 1. It is your duty to decide the facts in this case based on the evidence presented to you during this trial. It is also your duty to accept the law for my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law for my instructions to the facts that you decide have been proved, and in this way, decide the case. Keep in mind that charge is only an accusation. The filing of a charge is not evidence that the charge is true, and your existence as jurors must be made solely upon the evidence presented during the proceedings. The evidence that you are to consider during your deliberation consists of the testimony that you have heard from witnesses, stipulations, and the exhibits that I have admitted during the trial. If evidence was not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. Exhibits may have been marked by the court clerk and given a number, but they do not go with you to the jury room during your deliberations unless they have been admitted into evidence. The exhibits that have been admitted will be available to you in the jury room. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during your deliberations about the reasons for my rulings on the evidence. If I have ruled that any evidence is inadmissible, or if I have asked you to disregard any evidence, then you must not discuss that evidence during your deliberations or consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that I have admitted that relates to the proposition. Each party is entitled to the benefit of all of the evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness. You're also the sole judges of the value or weight to be given to the testimony of each witness. And in assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. In considering the witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things that he or she testifies about, the ability of the witness to observe. Those members of the jury, or that members of the jury, is the law that will apply in this case. So for the next 20 minutes, would you please give your attention to Mr. Thompson for his closing on behalf of the city attorney. Mr. Thompson.
Thank you, Your Honor. Now, all the instructions that the court just gave you are important. I'm going to focus on just a few of them. One, I want you to turn to instruction number 6, if you don't mind. This is called the to convict instruction. That's us in the community's shorthand version of what the state has to prove for the jury to convict the defendant. Also, it starts with the word to convict. Makes it very easy. Now, that on or about June 10th, 2024, everyone testified that this is the date it happened. So that's what I have to prove, that this happened on or about June 10th, 2024. We have proven that. Both witnesses testified this happened on June 10th, 2024. The defendant, Mr. Little, while in a transit vehicle, you saw the video, both witnesses that testified that he was in a transit vehicle, knowingly obstructed or impeded the flow of a transit vehicle. You watched the last 3 videos that Ms. Rowe played for you. You heard Mr. Rose talk to you about how long that vehicle had to sit at that stop waiting for Mr. Little to get off. He refused to get off for about 15 minutes. That impeded a transit vehicle. Interfered with the provisions or use of public transportation services. Just a different way of saying much the same thing. You'll see that there's a little bit of overlap in all of these ors. It's different ways to look at what can very much be the same thing. Unreasonably disturbed others by engaging in loud, raucous, unruly, harmful, or harassing behavior. The state's not asking you guys to consider that one, I'll be honest. I want to make it very clear, and I thought I made it clear in my opening, but I do want to reiterate it now in my argument. The city is not submitting to you that Mr. Little's behavior towards the bus driver is what constitutes a crime. It is not his interaction with the bus driver that constitutes the crime here. Make it very clear. His refusal to get off the bus when Mr. Rose asked him to, and his subsequent refusals to get off the bus by law enforcement is the crime. When Mr. Rose got on that bus as a supervisor, what's going on? No crime had occurred yet. That's not the state's position. It never has been the state's position. He informs him, he's like, Mr. Little informs Mr. Rose, his version of events. Again, we're not here to litigate what those events were. It's not important. It's not relevant. It's never been relevant. The interaction between him and the bus driver does not constitute the crime here. It was his interaction with Mr. Rose and his interaction with law enforcement. So, a brief explanation. Mr. Rose, as the supervisor, makes a determination. I got to get this bus moving. And for the other passengers' safety, for the bus driver's safety, the easiest thing to do is have Mr. Little get off this bus, catch the next one. Is it inconvenient to Mr. Little? Sure. It would inconvenience anyone who has to wait for the next bus. But a 30-minute inconvenience, as Mr. Little pointed out, versus the bus not moving at all. We can't go anywhere. Law enforcement now has to get called because he was angry at how a bus driver talked to him. He was angry that this young supervisor came up and didn't want to hear his full side of the story. And as he keeps repeating over and over again his civil rights, you will hear nothing in your, or you read nothing and heard nothing in your jury instructions about his civil right to ride a bus. That is not the law. There is no such law. In this case, this is the law, the jury instructions. He was given an order to get off the bus and ride the next one. It is unfortunate that the supervisor in the situation had the Explorer, not the F-150. I think that's what he said, it was the F-150. And he couldn't throw the bike into the bed of the truck. And the next step was catch the next bus. But that wasn't good enough for Mr. Little. Now, Mr. Little couched this in his civil rights and his this, that, and the other thing. That's not what this case is about. He didn't like how the bus driver talked to him, didn't like how the young supervisor talked to him, and he didn't like that law enforcement got involved, and he was angry and upset. And he dug his heels in, and it was his way or the highway. Now, you are free to watch all 5 videos. It's about 45 minutes for all 5 videos. I would encourage you to focus on, if you choose to watch any of them, the last 3, and you can feel free to click around to get to the part where you're talking, just for speed up the process if you so choose, or you're obviously free to watch it in its entirety. Again, the first 2 videos, the state is not alleging is any part of the criminal conduct. That's his interaction with the bus drivers, or with the bus driver, not part of the criminal conduct. It's what makes him angry, sure, but it's not what constitutes the crime. The other jury instruction I like to point out is what I have just said and what we'll finish saying here next couple minutes. What witnesses have said, what Ms. Rowe will say, none of that is law. The law is here. What I say and what Ms. Rowe says are not facts. The facts before you that you have to determine are the facts of this case came from the witness stand and the videos. Nothing I said or did, nothing Ms. Rowe says or does are facts and evidence, just the witnesses. Next, I do want to point out, I'm sorry, I did neglect to do one thing. The other prong I have to prove in instruction number 6 is that this happened in Tumwater, Washington. All the witnesses testified that this happened in Tumwater, Washington at the Linwood Avenue, or on Linwood Avenue. So the state has proven its case. Instruction number 7 talks about a person's knowledge and knowing. Another way of looking at this instruction is that ignorance of the law or a law does not constitute a defense. Whether Mr. Little thinks what he was doing was unlawful or lawful on the bus doesn't matter. What matters is, did he knowingly engage in the behavior he engaged in? And it's very clear from the video, and it's very clear from his testimony. He knew exactly what he was doing when he refused to get off that bus. He knowingly engaged in that behavior. He acted intentionally. Again, I would point out, he was not going to get off that bus unless it was on his terms and his terms only, and he wasn't willing to compromise. I'll get off if you give me a courtesy ride. Is that your bike? Yeah. I can't take the bike. It won't fit in the car. Well, then I'm not getting off. And he goes back to his seat. And then he refuses to get off when law enforcement tells him to get off. For 5 minutes or nearly 5 minutes, they talk to him, try to get him off. It's his way or the highway. Again, I would ask that you consider all of the evidence and focus on instruction number 6. And when you're done deliberating, find the defendant guilty.
Thank you, Mr. Thompson. Ms. Rowe, you have 20 minutes.
All right.
Your Honor, if I may, I'm going to do my closing from the desk because I have too much stuff that I need to reference.
You may.
You can, but you look like a sloth when you do that.
Well, good afternoon once again, ladies and gentlemen of the jury. In order
Okay,
for
I
a bus
got it.
driver
I got to speed it up.
to order someone off their bus, they need to have specific conduct that occurred that supports that would give them the authority to order someone off the bus.
Objection, Your Honor. Facts not in evidence.
I'm just going to remind the jury that the lawyer's remark statements aren't the law or evidence. Those are contained in my laws contained in my instruction. Evidence is what you heard on the testimony. Ms. Rowe, you may continue.
As we heard from Mr. Rose, the supervisor, neither the bus driver nor the supervisor, and I would even go as far as to argue, nor law enforcement has the right to order someone off a bus without reason. This was supported by Mr. Rose's testimony. No, we can't just get on the bus and order someone off without assessing the situation. Unfortunately, he did not assess the situation either thoroughly nor correctly. It was his conclusion that the driver was distraught. However, we heard the driver calling for the supervisor on the recording. That driver did not sound distraught. That driver was not speaking in raised voices, not when she called us dispatch. She didn't even sound as if she was talking fast. The driver called dispatch to request the supervisor at Mr. Little's request. There's a big difference there. Calling on your own because you're reporting harassing behavior, calling on your own because you're reporting aggressive behavior, or calling at the request of a client that you have ordered off a bus who has not committed any conduct that warranted an order to get off the bus. I'm hoping you will listen to the recordings, because what you won't hear is the bus driver saying, Mr. Little is speaking in aggressive tones and it's scaring me. What you won't hear is the bus driver reporting, Mr. Little was harassing me and it distracted me from being able to carry out my duties. There was no allegations of those behaviors even alleged. The bus driver called dispatch to request a supervisor at Mr. Little's request because he had informed her she had no right to order him off a bus when he had done nothing wrong. It's unfortunate that the supervisor appeared to the scene and concluded that the bus driver was distraught. It's unfortunate that the supervisor responded to the incident and he didn't even do a thorough investigation as to what specific conduct Mr. Little had engaged in before he was called that warranted a bus driver ordering off a passenger off the bus. There has been no evidence presented that would show any unlawful conduct that Mr. Little engaged in before both the supervisor and law enforcement was called. I find it very interesting that the state made sure to reiterate twice in its closing that, let's be clear, the unlawful conduct, in fact, let me
Is she drunk?
state it in his own words.
She sounds like she's slurring to me.
That it wanted to be clear that interaction between the driver and Mr. Little is not what constituted the crime charged. I would argue that the state has got it wrong. It's the conduct or the behaviors that Mr. Little engaged in before anyone was called that needed to support the bus driver's first and second order to get off the bus. The reason I would argue that actually the focus is backhandedly on the interaction between the driver and Mr. Little, it's further fleshed out in the jury instruction number 6. I'd like to review that with you. Before law enforcement arrived, Mr. Little had not engaged in any conduct that obstructed the flow of traffic or the transit bus. He had not engaged in any conduct that hindered or prevented access to the other riders. He had not engaged in any conduct before the supervisor and law enforcement were called that unlawfully interfered with others' use of the public transportation service. The bus was stopped at a break when the bus driver initially asked him about the battery. Mr. Little, whether he was annoyed or not with having to answer that question, answered that question, and the bus was still stopped and had not taken off. So that first bit of contact between the two did not interfere or impede or unnecessarily keep the bus driver there at the break for longer than she chose to. Next, the focus is on whether Mr. Little engaged in other conduct that was inconsistent with the intended use and purpose of the transit bus. He did no such action. He had done nothing. In fact, he was himself availing himself of the use and enjoyment of riding the bus. If you look at the law, it indicates that in order for the state or for you to find Mr. Little was guilty of unlawful conduct, you have to find that he knowingly obstructed or impeded the flow of transit. We've already discussed that. Whether he hindered or prevented the bus driver in her duties, we've already discussed that. Or whether he engaged in loud, raucous, unruly, harmful, or harassing behavior before law enforcement or the supervisor was called. He did not. At the end, I want to bring your attention to the end of that section of your jury instruction, because it indicates that he needed to engage in some of these conducts in order for the bus driver to even have a legal reason to order him off the bus. And that once either the transit authority or law enforcement lawfully commanded him to get off the bus, but first, it requires in and of itself for the supervisor, both the supervisor and law enforcement, to first order or ask or command him to cease such conduct. What is that conduct this statute is referring to? The conduct that had happened on the bus that occurred before state actors were called. You may have wondered why I asked both Mr. Rose and Mr. Little. At any time, did either law enforcement or the transit authority ask you to cease any conduct? No, they didn't. They didn't follow the rules. And them not following the rules is what violated Mr. Little's right to the full enjoyment of his bus ride.
Oh yeah, he wanted to
So
enjoy
I
that
would
bus
argue
ride.
that the focus is the only way the bus driver could have given a lawful command was after Mr. Little had engaged in some prohibited conduct.
Ride that bus, Mr.
I elicited testimony from the state's witness. It is not illegal to address a bus driver. It might be annoying to a bus driver, but bus drivers are well trained on how to ignore an annoyance. What happened this day was Mr. Little caught this bus driver in what I would characterize as a pissy mood. She was in a mood before she even asked Mr. Little about the battery. And when he answered her, because he was snippy in return, she unlawfully just threw out a veiled threat. Or it in fact, basically did what the state just is arguing that Mr. Little did. It was her way or the highway. You don't like the answer my question? You can get off my bus. She's not allowed to do that. That's unlawful. When the supervisor came to investigate the incident, you can see yourself, as we've all viewed, he did not give Mr. Little a chance to explain. He did not give Mr. Little the opportunity to educate him on what needed to happen before he was able to give a lawful order to get off the bus. Nothing supported any lawful order that had happened prior, supported any lawful order by either the bus driver or the supervisor to order Mr. Little off the bus. I found that it was very interesting when Mr. Rose indicated that there are times when an operator, meaning the bus driver, can escalate the situation. That's what happened today. This bus driver was having a bad day, and she let Mr. Little know it the first time he seemed annoyed that she asked him about a box that was clearly not a battery on the bike. But he acquiesced and answered her. The bus driver had no further problems until it appeared to Mr. Little that she closed the doors without allowing the last passenger to fully exit the bus. It was not unlawful for him to notify the bus driver, hey, you closed the lady's arm in the bus, in the door. But it was clear what mood she was in when she responded to that. She didn't say anything about it, and neither should you. In fact, when she called dispatch, she told dispatch that Mr. Little had accused her of closing the doors basically too early. That happened. What she didn't do is say, Mr. Little cussed me out. Mr. Little threatened me. She simply said, basically, I'm annoyed and I want him off my bus because he's invoking some civil rights. That's what happened. And he had every legal right to refuse to get off the bus because before the supervisors and law enforcement arrived, he had not engaged in any prohibited conduct that warranted and would have supported a lawful order to get off the bus.
He was just
In voir
engaged
dire,
in a little
I
bus
asked the
enjoyment.
jury pool, how many believe that the officers always get it right? And all of them, including yourselves, acknowledge officers don't always get it right. Well, this incident, the supervisor got it wrong and law enforcement got it wrong.
Oh, and I have
Mr.
it
Little
sped
has
up.
done nothing wrong. And that is why he was so adamant in his refusal to get off the bus. The supervisor also indicated he could have offered, since there had been no specific conduct, that he specifically requested Mr. Little to cease as the statute and the law required. Because of that, there was no conduct. He could have easily done what he asked, testified that he could have done. He could have said, Mr. Little, this bus driver would rather you not speak to her. Then he would have satisfied the policies and procedures that were required before ordering someone off the bus. No one ever did. Unfortunately, both the bus driver, the supervisor, And unfortunately, even the responding law enforcement never followed the statute's requirement, and that is to first request that the bus rider cease such conduct. Because they didn't ask him to cease any conduct, because really there wasn't any conduct that he needed to cease, as he testified himself. It was right before his stop. There was no further communication between he and the bus driver. That's what made the order to get off the bus unlawful by both the supervisor and law enforcement. And it's ultimately the reason why he was arrested.
Ms. Rowe, you have one additional minute just to let you know when your time's almost up.
I'm asking that you, as jurors, glean over the evidence. I'd ask that you rewatch the video. And I ask you to determine that Mr. Little's communication with the bus driver was in no way unlawful, and that he is innocent of unlawful bus conduct. Thank you.
Members of the jury, the state carries the burden of proof in these cases. As such, they're entitled to a rebuttal. And so, Mr. Thompson, you have 7
No
minutes.
unlawful bus conduct.
What you won't find in your jury instructions is some sort of policy and procedure laws, some statute.
That was their land.
What lawful bus riding rights exist, because they're not part of this case. This is not a civil rights case. It's not a civil rights lawsuit. This is not what Ms. Rowe is trying to make it sound like. This case is about your jury instructions and the facts that came out in trial. Okay. Now this is going to sound a little backwards, but the ceasing that Ms. Rowe keeps talking about, she's talking about Mr. Little's interaction with the bus driver. And I again will stress to you, that is not what the state is alleging is the crime here. Mr. Little refused to get off the bus. The supervisor and law enforcement asked him to cease his sitting and refusing to comply. That's the conduct. Refusing to get off the bus is the conduct that he was asked to cease doing. But separately from this, he impeded the transit. He's not allowed to do that. He delayed this bus 15 minutes. Now, again, defense has, and I told you in my first closing, that defense was going to talk about the interactions between the bus driver and Mr. Little. Again, that is not what constitutes the crime here. Now, Mr. Rose on the stand reiterated some of the rules, not all. I mean, to be fair, I'm sure there's a laundry list of rules that people have to follow on the bus. But he gave you an example of one, which was sleeping, right? And we may not necessarily intuitively think of why a rule exists or the reason for that rule existing. To be frank, it never even occurred to me why sleeping on a bus might be problematic. But an emergency slam on the brakes with his explanation, person goes flying, could hurt himself or another passenger. Absolutely made sense to me in that context, right? Another rule he did say when asked was, do you have to follow the directions of a bus driver and transit employees? He said, yes. Directions of the bus driver and transit employees. Mr. Little was ordered, or not even ordered, he was asked, you get off the bus, take the next one, solves the whole problem, right? Bus driver feels uncomfortable around you, you guys aren't meshing, something's going on here, take the next bus. He refused. So the supervisor again asked him to cease his behavior of refusing. Get off the bus. Law enforcement needs to come. Hey man, you got to get off the bus. He again refuses to cease that behavior of refusing. You don't get to refuse reasonable orders here. You don't get to refuse. He's impeding the flow of the transit. Now, what you won't hear in your jury instructions or see in your jury instructions, really any of the things that Ms. Rowe called law or policies, procedures, there's nothing in your jury instruction number 6 that says prior to a transit employee ordering someone off a bus, they must have a lawful basis to do so. That doesn't exist. There's nothing in your jury instructions about what transit employees can and can't do because they're not on trial here. Ms. Rowe spent a lot of time trying to make this a trial about how rude and inconsiderate the bus driver was to Mr. Little. And I'm not in a position, nor would I be in a position to defend any of her behavior. Was she short-tempered? That's up for you. That's for you guys to decide. I would argue that it's not relevant. The question is, did Mr. Little impede the transit vehicle? And the answer is yes. He refused to get off the bus for 15, 20 minutes. So much so that he impeded that bus so much so that a bus that runs every 30 minutes, while Mr. Rose was still writing out his one-page statement, the next number 12 came by. That's how long Mr. Little impeded that bus. That while he's writing a one-page statement, the next bus was already there. Don't let defense confuse the issue here. Don't let defense make it seem like the transit employees had to follow some magical procedure that doesn't exist before asking Mr. Little to get off. Back in jury selection, I asked you about, I gave a scenario about planes. I gave a scenario about me being in a government building, sticking my phone in people's faces. And security comes up to me and says something along the lines of like, you can't do that right here. You're, you know, if you want to come back and film later, sure. And, you know, he's in a public place. Yeah, sure. He can ride the bus. They weren't trying to deny him his right to ride a bus or his ability to ride a bus. They wanted to separate him from the bus driver. He refused, not because of some civil rights thing. That's something he's latched onto because it sounds nice and fancy. He was angry at the way the bus driver talked to him. He was angry that the young supervisor was talking to him in the way he found offensive. And he dug his heels in and he wasn't going to change. We know he felt that way because he started complaining about young college kids and then he kind of trails off. His behavior and demeanor, you guys should consider when looking at the video here. Looking at his demeanor here. Look at his motivation for presenting things in a certain way. Your jury instructions do tell you to consider those. They don't tell you to consider what Ms. Rowe was talking about, is some sort of magical policy and procedure or lawful reason this or lawful. None of that is true because it's not in your jury instructions. It's not in the evidence.
Mr. Thompson, you have 1 minute.
Thank you, Your Honor. Again, that on or about June 10th, 2024, which the state demonstrated with all the witnesses, the defendant, while on or in a transit vehicle, he was in a bus, knowingly obstructed or impeded the flow of a transit vehicle. He delayed that bus by 20 minutes, and he did so knowingly. Unreasonably disturbed others by engaging in loud, raucous, unruly, harmful, or harassing behavior. Again, I would say that behavior ties more towards the bus driver, but that's not what I said. I was alleging. Again, the state is the one alleging the incident. Ms. Rowe doesn't get to decide what part of this is the crime. Although, if you hear about his, or if you would listen to his conversation with Mr. Rose versus his testimony here, he has no reason to yell. Not at least the way he presented. He was talking in a relatively voice. In fact, at the beginning of this, he was talking so quietly that some people might have had difficulty hearing his initial testimony. He gets animated, he yells, and his voice goes up. He got animated, and he was yelling. But more importantly, so I would say impeding the flow of transit vehicle. But more importantly, he refused to obey the lawful commands of the agent of the transit authority, the bus driver and/or law enforcement. The bus driver and the cops told him to get off, cease his refusals to comply, and he refused. We ask that you find the defendant guilty.
Members of the jury, the 6 of you, except for you, sir, in the back, can be taken back into the jury room where you begin your deliberations. Juror number 7, I'm just going to have you wait right here. Ashley's going to come by and get your phone number, your contact information. You're still part of the jury. And so I've had the experience before where people start deliberating and then an emergency arises or someone gets sick and then the alternate has to get called in and then you have to start all over again. And so we'll take your phone number. We'll keep you informed. If a verdict is reached, we'll let you know. And then, but for right now, I'm going to have you stay while the other 6 go back and begin your deliberations. You could say there, you could be seated. And I'm informed you've reached a verdict.
We have.
And then do you have the verdict form? Presiding juror.
It's right next to you.
Oh, I see. Okay. I didn't realize here. You can be seated. You can be seated. In the case of City of Tumwater versus Kenneth Little, the jury verdict reads as follows. We, the jury, find the defendant Kenneth Ray Little not guilty of the crime of unlawful transit conduct as charged in count 1. So all members of the jury, I'm going to start with you, ma'am, and I'm going to ask you 2 questions. My first question, is this your verdict? And then is this the verdict of the jury? So ma'am, is this your verdict?
Is this my verdict?
Yes,
Does it have to be unanimous?
yes, it does.
Oh,
That said, that was pretty clear in the jury instructions. Are you telling?
when I talked to the clerk, she said that if it's like 4-2, because it's leaning more towards not guilty, that we do it, whatever.
Okay. So what did you say? So, can you hand me the jury instructions? I'm sorry?
I did read that in the instructions that it had to be unanimous.
Yes, it does.
Okay.
And
I
so,
understand that.
well, the last paragraph of the final instruction says, because this is a criminal case, each of you must agree to return a verdict. When all of you have so agreed, fill in the verdict form to express your decision. Presiding juror must find the verdict form and notify the clerk, and the clerk will bring you into court. And then you are the presiding juror.
That's correct.
And then, so when the verdict is reached based on that instruction, I don't know what was said to you or what was understood or maybe misunderstood. But the question is was this a unanimous verdict? The answer to that's no, then,
We will probably need to go. into-
okay, so ma'am, I'm talking to you, ma'am, so I need you to
Yes,
talk to
yes,
me.
sir.
So is this your verdict? The verdict of not guilty? I mean, everybody is, it's got to be unanimous. It has to
No,
be.
I understand that. So that's why I said we need to go back in and talk about it in order to be able to come back with unanimous verdict.
Okay.
That's what I'm saying.
Uh,
We need to discuss.
Okay, thank you, ma'am.
Okay.
Thank you. Yeah, I'm gonna, you can go back into there and don't deliberate. I'm gonna discuss things out here for just a moment. You can go back into the courtroom
Thank you.
and stay there for a moment. So this is a new one. So yeah, I'm not too sure where we go from here. Sorry, don't worry about it. Don't worry about it. So I guess I'll get input from both attorneys. They could send back, they haven't reached the verdict, and I don't know what the count is. And if they haven't decided, they can just keep deliberating and go from there.
Well, I believe the juror indicated the count was like 4-2.
So, which is a hung jury.
Yes, Your Honor. Which I suspect one of the following questions might be based off the prior questions. What do we do if we can't reach a unanimous verdict?
Well,
So if the court is asking my suggestion, I would ask the court to give the jury a little more time to see if they can come to a unanimous decision in hopes that we can finalize this case today.
Maybe she can sober up enough to drive
well,
home.
it's now 6 o'clock, essentially 5:58. I'm gonna bring them out. I'm gonna have them continue deliberating and we're gonna go for about 15 minutes. And then I'll let them talk about it. We'll come back in here after 15 minutes. And then if they, I'll ask them if there's a probability they can reach a verdict. And if, or just, yeah, we'll do that. Go ahead and bring
I'd
it
ask the
back.
court not inform them how much time you intend to send them back for.
What's that? I'm not gonna inform them. I'm telling you.
Thank
I'm
you,
not
Your
gonna
Honor.
tell
I
them.
just want to
Yep, no.
make that clear. Thank you.
And then if they, and then, yeah.
I think that's all we got.
And Your Honor, if we can just provide them with a blank verdict form.
All right, there you have it. There you have it. I don't know what's going on. Everyone's gonna ask me as if I'm not omniscient. That was the last video. As I started this stream, the trial was in process, so I did not know the result. And they just kept tacking on more videos. Had I known what I was getting into, I probably wouldn't have. But I did. You're welcome, Iris. You're welcome. I would think that let me put it this way. That was over an hour ago. I'm just looking at when they posted that stream. So I imagine they went home for the night one way or the other. That they either were at an impasse and couldn't decide, and the judge just declared a mistrial but didn't come back on YouTube to do it, or I guess they reached a verdict but didn't come back on YouTube to do it, or they went home and they're still deliberating about it. I understand it. I would have found the guy guilty all day long based on what I saw, but it's a case you can go either way with. It's a matter of degrees. Like who do you think was out of line? Do you think the bus driver was cranky? I thought that he was the one out of line, and they asked him. The bus driver asked him about if he was carrying a battery, because that's it, and that's what started the whole problem. And I couldn't see the video well enough or whatever, but I can see where that would irritate him a little bit. But then I can just tell he's like that. But they're leftists out there. They hate the police. That's how they roll out there on the left coast. And so this doesn't surprise me at all. And I'm all for right. Like, here's the thing. It doesn't bother me so much. And there's some flagrant violation. Like, we don't have him hitting somebody on video or something like that. You've got conversations between him and the bus people, and the way you interpret those is subjective. And I think you can perfectly, within the law, come back with guilty or not guilty in this. I would have come back with guilty, but it doesn't shock my conscience that people came back with not guilty. So it sounds like it was 4-2. There were 2 people who are like, hell no, that guy wouldn't get off the bus. He's a jackass. That's a guilty. And then you had 4 that just you got jurors out there. They're all, most of them have had run-ins with the police themselves because, that's the world we live in now, right? You do not get full enjoyment. Oh my God, Mr. Little talking about enjoying his bus ride. Like, it really got creepy. It really got creepy. So of course I had to step into it with the title now. So I personally would have found him guilty from what I saw. I mean, it would have been better if I would have seen the video. Ultimately, they said, okay, you're getting on our nerves. You need to leave the bus. And he wouldn't. I think that's just pretty clear. And all this is, I saw in the chat, like, oh, what are you going to do for sentencing? I'm like, I think this would be a fine. Like, I think they'd assess $120 fine or something. I doubt they would set it over for sentencing. It was interesting. At least, okay, we didn't get a verdict, but we did get the jury to come back and say wacky stuff like, oh, we had no idea it had to be unanimous, which it doesn't always. In their defense, it doesn't always, but it usually is the case. That's the most common thing in the U.S. system. I don't know. All I can tell you is I've had years of juror questions, and They're not good. As a rule, the jurors ask some bad questions and focus on the wrong things. They do. They do. It's a terrible system. The jury system is a horrible, awful, inefficient, crappy way to resolve disputes. The only thing it has going for it is it's better than any other system that's in the world. And that's the truth of it. And on that, peace out.